Yes.
May I please, Your Lordship? We have filed an interlocutory application for correction of an order, Your Lordship. Today, Your Lordship, will it be possible? Okay.
May it please, Your Lordship. Item number 47, my lord. Yes. With the consent of the other side, my lord, may I pray for 2 weeks adjournment to find a response? Okay. Both sides are represented on the prayer made by and counsel. Respond number 6. Matter stands adjourned for the ability to file affidavit in opposition in the matter. List after 2 weeks. 2 weeks. Any interim order operating? No.
Madam, can we fix it, madam?
Did make a mention because after make a mention. Wait for below. Best.
I beg to mention item number 25 now.
25.
This matter has become infectious.
Okay. Upon instructions, Mr. A.K. Gupta and counsel for the petitioner submits that the matter has become infructuous. Mr. M.D. Boral and standing counsel for the transport department is present. RB?
Oh, sorry.
RB
MD Boral may be
present. Matter is closed on having been rendered infructuous.
Okay. Wait, please, Your Lordship. I beg to pray before listing this matter, Your Lordship.
Listing due to the purpose of listing due to the purpose.
May it please, Your Lordship, I beg to mention item number 19 of today's list, my lord. I have
Yes.
taken the consent of the other side. Can it be fixed on Wednesday, my lord?
Both sides are represented. List on 1/5/2024 as prayed for by the counsel for the petitioner.
With consent of the respondents, my lord, I would like to mention item number 46 of the daily list.
46.
46, my lord. My lord, Dr. Sharaf is unavailable, my lord. Can it be after 2 weeks or 3 weeks, my lord, if Your Lordship permits? We have the consent of the respondents.
Okay. Both sides are represented. Prayer made by the court for the creation of the participants adjourned today. List after 2 weeks.
Oblige, my lord. Lordship, I beg to mention item number 34, Lordship. My father become infectious, Lordship. 34.
You're taking consent of the other side.
Matter become infectious, Lordship.
You go check closed. Okay. Both sides are represented. All sides are represented. Mr.
Gigi Guzman.
Gigi Gogol and counsel for the petitioner upon instructions as submitted for the matter has become infructuous. Since those having been rendered infructuous.
May I please, my lord? I beg to mention item number 52, my lord. This item has wrongly listed before Your Lordship, my lord. Item number 52, my lord.
Okay.
We will approach the registry for listing the matter before the appropriate form.
Okay. Which was represented, Mr.
DM Nath.
DM Nath, counsel for the applicant submits that the matter has been wrongly listed before this bench. The registry shall examine list the matter before the appropriate bench.
My lord. Oblige.
May I please, Your Lordship? I beg to mention item number 30 of today's daily list.
30.
30. Your Lordship, maybe adjourn for 2 weeks.
List after 2 weeks is paid for by the counsel for the petitioner.
Supply item 53 for withdrawal.
Matter is withdrawn with Vivati.
Upon instructions, Mr. P. Sharma and counsel for the petitioner seeks to withdraw this petition. Mr. A. Barwar and counsel for
Aviator by Velas.
On behalf of
Sure.
Matasa,
For,
KVA, private respondent.
for the caveator. The private respondent. Forest will be there. So R. Google, standard for the Forest Department. PCB is Mr. Mr. S. Barber and standard for the Pollution Control Board. Present and Ms. S. Barber and government advocate are present. Matter stands closed on withdrawal. Any interim order operating?
No, Lordship. Which liberty, Lordship?
Why Liberty?
Liberty, Lordship, that there is compromise talk between petitioner and respondent number 2 and 3 is going on, Lordship. So is the instruction that there is possibility settlement.
I mean, this matters, they can't be compromised.
There is nothing less as such because
They are already in
violation.
When pollution control is involved, they cannot be a compromise.
Then the visitor can be fixed for admission if liberty is not granted
Hmm.
next week, Lordship. Date
Because
may be
this
fixed if
is not a matter where it has to, it can be compromised. It's a case of big in industry where there is a complaint of public complaint of
Yes.
polluting.
Yes.
Even if you want to, will not permit that compromise. Because it's a discretion of the jurisdiction and discretion of the pollution control board to find out the truth. Okay.
Next week, Lordship, for admission.
You see, office representative. The Grand Council for the petitioner had paid for allowing the court to withdraw the application with liberty to approach again. On the ground that the talks of compromise are going on. Next para. In view of the subject matter of this petition. Where the issue of pollution is involved. Liberty to approach again cannot be granted. Next, for the company, the council for the petition place that the matter will be stated in the admission column, please. List then,
And next week, any date, Lordship, if possible.
give a date after next week, so the 3rd of May. Okay.
3rd of May.
Of like,
Daily list item number 14, motion.
Lordship, the counsel for the petitioner is on legs in another court. My lord
Just
may
wait.
take up this
Just-
matter after
just-
some time.
Just. Okay, after some time. Two and three,
2 and 3.
Yeah, please, your lordship. Lordship, matter may be possible for the time being, lordship.
finding.
Lordship.
Four,
May it please, your Lordship, my lord.
yes,
My lord, here in the order dated 10/4/2024. My lord, as per this order, the additional senior government approval was obtained directed to obtain instruction as to whether they have passed speaking order on the basis of order passed in the writ petition earlier, my lord, 1/4/2014.
where is that order?
Page 25, you know, in the writ petition. Relevant portion is page 26.
from the below second paragraph.
Where is the notice?
My lord,
Which page is the notice?
page 35, my lord.
37.
Yes. Notice dated 13/3/2024.
You have got any instructions? No. You look at this notice. So your representation at page 37. In matters of eviction, can you file a representation and then say that you don't give effect to, you'll have to participate in the proceedings.
My lord,
When an eviction notice is issued,
my lord.
you'll have to participate in the proceedings.
That's correct, but my lord, the thing is that, my lord, here in the same plot of land, my lord, that I just shown, my lord, that order on earlier occasion, my lord, page 25, that order, 19/3/2024. At page 26, second paragraph from the below, my lord. Since it is specific allegation that the petitioners that they have been served with the notice dated 29/11/2012. This
You
is
see, this-
in the earlier notice.
You see, an eviction process was initiated. Enforcement proceeding was initiated. After that, can anything happen by way of representation?
My lord, it is pursuant to the order of this honorable.
No, I
court.
understand, but these orders will not be implementable because otherwise also you see, where is the power of the authority to act and by way of an representation? There is an enforcement proceeding. You participate in the proceedings.
You know, because they, by the notice, my lord, they had said to evict, to clear the land, man. They,
Correct.
not for, my lord, participating, my lord. To vacate the second paragraph of the page 35. Therefore, it is hereby inform you to vacate the land. We are in the land since 1976, my lord, 79. And there was earlier, my lord, one, and GMC has assessed the land, my lord. I have given the copy assessment of GMC and the electricity connections, everything is there. Now page 24.
That's fine. Yes, Mr. Barua,
Yes,
you got instructions?
in fact, from his petition, what we can make out, it is a Porusala bill. This is a water body. Already he is in illegal possession over that. And prior to that, in the standard Kobula, he ought to have given any application that hasn't been approved any time. Only after this notice has been issued duly, instead of participating in that proceeding, he has approached the court and.
No, but there's a difficulty also.
Yes.
Yeah, on 18/2, I think there is a judgment of this court. The government has not given a window. The people who are receiving notice under 18/2 to make their projection before take their defense before the authorities. It's kind of one-sided
Yes.
proceeding. So let us say he's saying that, you see, right or wrong, we don't know. He's saying he's there from 1976. Now you create a situation where under the land laws of the state, along with the notifications issued for the Vasundhara scheme, to have a land allotted, you will have to be in occupation of the land.
Yes.
So he's in occupation of the land. So you create a right in favor of encroachers. You want to create circumstances where people go and encroach. You see, why will this scheme be there if you don't want an encroachment? Because the
That-
government.
That method is pending before the division bench. And
What
it is
about
fixed on
the notice
30th.
of consent?
But you have to stay till then. You see, you create a situation where you want people to encroach. The government's will is there to encroach. That means it is pick and choose. You will be evicted. In the chair you have vacated, anybody else will come and sit. I'm not pointing out Mr. Borpujari, but I'm just, it's just an indication of finger. So somebody else comes and sits there. Can that be permissible? You can choose policy. You have a scheme, you go by that scheme. And the land to be encroached is permissible on a wasteland. You can't say that bill is not a wasteland. It may be a water body, but you have not invoked that water body act.
Right.
You have invoked 18(2). And then if you can show that this bill is not a wasteland, you save yourself, otherwise you'll have to stay this. So DK Das will counsel for the petition. The petitioner is in receipt of a notice. Where is that notice?
Yes, Malad, page 35.
36.
As-
36.
Assamese version is 36, Malad.
Yes,
Bedokol
receipt-
Janoni,
receipt
eviction
or
notice.
dated number. Page 35. Notice number so and so. Dated so and so. Informing her
To vacate the land within 3 days.
no, then what right the petitioner has? This notice is issued to Damayanti Deka. You are not Damayanti Deka.
Yeah, Malad, she already died, Malad. And we are, she is our mother-in-law, Malad. Our husbands are also expired in the meantime, Malad.
Joba.
Joba is the first, Malad, daughter-in-law, and next one is the Malad, the second daughter-in-law. I have stated.
Okay. The petitioners have been served with the eviction notice,
Paragraph 2 I stated.
which is addressed in the name of Damayanti Deka, Damayanti Deka. Full stop. It is projected that the noticee has expired in year 2010. And her 3 sons. No, you died when?
Malad,
2010.
Malad, Damayanti, she died on Malad, 3/7/2012.
3/7/2012.
Yes. Prasanto Malad, he is the
and
elder
her-
son.
And her 3 sons.
Yes.
Prasanta Deka expired in the year 2010. Diganta Deka expired in 2020. And Debo Deka, DEBA Deka, expired in 2016. And the 2 petitioners herein are the wife of the first and third son of late Damayanti Decca. By the said notice, the petitioners, the petitioners to their deceased mother-in-law were informed that through notice issued to the deceased mother-in-law, was informed that they were illegally occupying government land of Sorusola, SORU-SOLA Bill, covered by dark number 795/771 of village Guwahati Part 2 under Guwahati Moza. And therefore, they were asked to vacate the land within 3 days, during which action under section 18 within bracket 2 of the Assam Land and Revenue Regulation was written. Full stop.
Para 3
It
also
is-
important, Malad. Para 3.
It is projected that the the respective husbands of the petitioners on an earlier occasion approached this court, and this court by order dated 19/3/2014 passed in WPC 1489 of 2014 permitted the petitioners to respond to the said notice by filing representation within 31/3/2014, and the authorities were directed to dispose of the same by passing a speaking order. It is projected that the outcome of the said representation has not been informed to the petitioners, and that on receipt of the impugn notice dated 13/3/2024, the petitioners have again submitted their representation dated 29/3/2014 to the Additional Deputy Commissioner, Kamrup Metro, Guwahati. And to the Circle Officer, Kamrup Revenue Circle, Guwahati on 15/3/2024. Which has not been disposed of. Next paragraph. Accordingly, this repetition has been filed in Article 56 of the Constitution of India. Next paragraph. This case, this court by order dated 18/3/2024 directed the government advocate to obtain instructions as to whether the deputy commissioner, district commissioner, had passed any order in terms of the hearing before referred order dated 19/2014, which was reiterated by order dated 10/4/2024. However, Mr. S. Barber and the government advocate submits that he has not received any instructions. Next paragraph. Accordingly, let a notice returnable in 4 weeks be issued. Mr. S. Barber and the government advocate accept notice on behalf of respondent numbers
2, 3, and
2, 3, and 4. Mr. A. Bhattacharya, and then standing also for the unit department, accept notice for respondent number 1. Accordingly, formal steps, issuance of formal steps is not required. Next paragraph. Extra copies of the requisition will be served on them in course of the day. Next paragraph. Having noticed that under the schemes formulated by the government of Assam, comma. On one hand, the government encourages encroachment on government land, which is otherwise a wasteland, which is a precondition for applying for settlement of the land in their favor. On the other hand, when encroachment is made, then the land revenue authorities under the district commissioner issue notice on the encroacher, getting them a violation under section 18 within bracket, rule 18 within bracket 2, read with section 165 of the Land and Revenue Regulation, 1886, which appears to be a contradictory approach of the contradictory and self-defeating approach of the government. Full stop. Next one, be that as it may, this court had issued a direction by order dated 19/3/2014 in WBC 1489 of 2014 to dispose of the representation of the petition, the representations filed by the husband of the late deceased husband of the petitioners. The result of such an exercise has not been disclosed despite orders dated 18/3/2024 and 10/4/2024. In view of above comma. The interim order passed on 18/3/2024, not to give effect to the pure notice dated 13/3/2024, which was extended by order dated 10/4/2024, stands extended till further orders. Just after 4 weeks.
Oblige.
Item 5.
Item 56 may can be taken up with the lordship.
56.
56, same issue law. Your lordship, I am on against the letter dated 18/3/24 or 19/3/24
Mr. Bapuzari,
at page 29.
operating a what do you call mall culture here, 1+1 free. He's getting one matter listed and asking us to take another matter.
Yes.
See, no objection from you.
No, see, we take it up. Otherwise,
We have
I will-
56.
I will submit my note.
Page 29, lordship.
Just a moment.
The proposed cancellation of the settlement.
Just a moment. You have to issue a notice here. This cancellation of Kabula.
Lordship will kindly keep the maintainability of the petition open because it is only the my lord internal communication going on between the my lord authorities. Now, my lord, rightly or wrongly, my lord, a part and parcel of land has been settled. It was settled on the strength of it, the genesis was the report given by the circle officer. Now, at a later point of time, the authorities found that that report was defective. So the land could not have been settled. Now an exercise has been undertaken by the authorities. Thereby, my lord, the deputy commissioner is making a communication to the department that this that earlier letter that may be treated as cancelled. So no final decision has been taken. So he is not a person agreed. Lordship will kindly keep the issue of maintainability open.
Prior to-
But in the meantime, you're also threatening eviction process.
No, that matter, my lord, there is a series of matter where, my lord, another writ petition has been filed by the writ petitioner, present writ petitioner. And my lord, already they are protected in the interim. A bunch of cases, my lord, it was listed yesterday. Then, my lord, the next date is, my lord, on 21/5. The lordship can also post this matter on
Yeah.
21/5.
Okay.
After issuing the notice, lordship may.
Notice may be issued, my lord.
Okay.
Because here there is no question of stay, my lord, because
No, I'm not.
it is only the internal communication. No, my lord, indefeasible right has been, my lord, created, accrued in favor of the writ
No,
petition.
you have filed an earlier petition.
That serious matters is earlier regarding that
I'm not asking
eviction.
about series matter. I'm asking about this petitioner. Whether this petitioner is filed or not.
Filed petition against the eviction notice.
Okay, so you're protected.
Yes, they are protected.
Mr. R. Dhorlan, counsel for the petitioner. Mr. R. Bhattacharya, standing counsel for the Revenue Department, representing respondent number 1.
One, my lord.
And Mr. D. Nath Leonard, senior government advocate, appearing for respondent number 2, 3, and 4. Issue notice on, including notice on the prayer for interim relief returnable in 4 weeks. What is the date, next date?
My lord, 21 of May, 21st of May.
Returnable on 21/5/2024.
If you look at page 11, the last portion of their para 8, they have already indicated Mulak, that notice was issued and it has been stayed. Mulak. It is- the
Just
case is
okay.
pending.
That's why we asked.
Case is pending.
As all the respondents are represented, formal, the issuance of formal notices dispensed with. So however, extra copies of the writ petition be served on the learned state and department council in course of the day. Based on 21/5/2024.
Along with,
I'm not saying that, it will always come. We should say the same day. And this,
it's also same law.
same, okay.
Let the returnable date be on 21.
Same,
21. Got it.
I'm so obliged. my lord.
Obliged.
Item 5 also same.
5 and
Item-
56
item
are identical, my lord.
5 and
5 and 56.
Ah.
Obliged. my lord.
Item 6.
Maybe,
Yes, Mr. Jha.
Your lordship, in this case, the petitioner and respondent number 6 are neighbors and relative, your lordships. Your lordships, please peruse page 97, your lordship, then it will be clear, your lordship. The map, where we are residing, your lordships.
You've already approached the civil court.
So I approached the civil court for different matter, your lordship, because he blocked my roads. And thereafter I appeared before the, approached before the civil court, and civil court has granted me injunction. Here in this case, this respondent number 6 has got the this building permissions by covering that very approach road, your lordship, as his land. So this is my grievance.
There will be a disputed question of fact in the writ petition can't be determined.
No, it is not disputable.
No,
Your
no,
lordship, I'm showing.
Everything is okay. You see, in every civil suit, everybody has a document to show that his land is bifurcated land, it is specific land, it is in the place X.
My case is
But
not this,
still
your
people
lordship.
encroach and then we file a civil suit.
No, my case is not this, your lordship. My case is that this respondent number 6 applied for building permissions before the authority, your
You
lordship.
see, you have already a remedy. 133 is available under the CRPC. If they have blocked your passage.
He's not,
it's a-
he is not blocked my passage as of now because there is an injunction of the civil court. Problem here is he got the building permission for construction of the buildings and including by these roads in their approved plan, your lordships. What went thereafter, your lordships? I filed an application before the GMDA, your lordship,
Where is your plane?
client, your lordships.
Yes, where is that? Is it page 31?
Your lordship, first document. Page 46, your lordship.
Look at prayer two. You risk a dismissal.
Prayer person is at your lordship.
Look at prayer two at page 41.
Your lordship. Your lordship. Your lordship, this is there. My case is different, your lordship. I am
You
about,
go- Once you approach the civil court, you go there. You can't be parallel.
I'm there, your lordship. I'm there. My only offense, I'm showing two documents, your lordships. I applied for the, he applied for the
You-
permissions.
You don't want to damage your civil suit.
Your lordships, it is,
Because if I'm issuing a notice, then it will be a clear cut direction to the trial court, not to adjudicate upon anything concerning with the road.
your lordships, I am, my humble submission, your lordships, it is not
No,
about.
I'm also submitting very humbly.
Your lordship, one thing may be, your lordship, I may be so, your lordships, 161, page 161, your lordship. I'm not
161.
here, 161. I'm only about the building permission granted to the respondent number 6, 161, your lordship.
1.
This is your lordship, Chief Executive Officer, GMDA, addressed to KNC consultancy, the respondent number 7. Where it is found that the planning permit number so and so dated so and so issued in the name of Nakibul Hussain Chaudhary at the Hidayatpur near during the verification, it is found that the permission is accorded showing the road ended in the applicant plots. But the road is actually ended in the next plot belong to the Qutbuddin Ahmad, the petitioner hearing. Land area as document are 65.5 square meter, but planning permit and building permit are issued over 66.78 meters of the land area. Since you are impelled registered technical persons of the said project, you are hereby asked to show cause as to why this is the show cause given to this respondent number 7, your lordship.
Correct.
Because he exceeded his jurisdiction by giving the permission by as per without verification, even if he verified, your lordship, then also he suppressed. My question, my only grievance is, your lordship. Thereafter, your lordship. Next document, your lordship.
Mr. Jha, I'm asking a very, very simple question. What happens if your civil suit is dismissed? You ask for a declaration that this road, there should be no construction.
Your lordship.
Now, what happens if the suit is dismissed?
Your lordship, I will be dictated, your lordship.
Then the construction can come up. So you want to block that by filing this writ petition. That's why I'm saying, please sit down, have think over. You want to proceed with this writ petition, or you want to proceed with this?
I'll proceed with the civil case, your lordship.
Let me close this. You raise this point there.
Your lordship, my submission hearing, only your things, your lordship, building permission granted in by passing the law, your lordship. Here, one document, your lordship.
They have proceeded
I'm
against the
to
architect.
that permission, your lordship. One thing, your lordship, page 163. Here,
That's why we are asking you again, this is the second time asking you. If your civil suit is dismissed, will there be any impediment for the person to construct as per the planning permit? No.
oh, your lordship. Your lordship, then also in this case, your lordship, I proceed with the civil case.
You permit you to raise the plea there, correct?
Good.
But Mr. Anand Jha and counsel for the petitioner, as well as Mr. S. Bora Leonard, standing counsel for the
GMT. Respond number 5.
GMT representing respondent number 2
to 5.
2 to 5. Mr. S. Barwad and government advocate appearing for respondent number 1.
State of Assam is not represented here.
Huh?
Respond number 1. State of Assam with no department is there.
It's okay. She can still appear. It's fine. As the court finds that the petitioner has already approached
the civil court by filing title suit number 436 of 2021. The court is of the considered opinion that for the that if this repetition is entertained, it will be a parallel adjudication which will touch upon the issue involved in the suit. Accordingly, the court is of the considered opinion that the petitioner be granted liberty and be delegated to the civil court to raise the plea which is sought to be raised in this writ petition. Next, will be aforesaid liberty. This writ petition stands closed without adjudicating any issue raised in the writ petition on merit.
Not clear. May I please, Your Honor? My Honor, Your Honor, you had passed an order, my lord. That's page 82, my lord.
Page 82.
Your lordship had passed that order, setting aside this stop construction notice issued by Surupatar Municipal Board by order dated, my lord, 28/6/2023. My lord, eventually what happened, my lord, after setting aside of this order, they again issued me another stop construction notice. Initially, one show cause was issued, we replied, and immediately on the date of reply, they issued a stop construction notice. Your Honor, your second notice will find it page number 77. My lord, I read out that in continuation of the earlier notice, SMB
Page.
0
Page.
page 77. ma'am. 77.
You got any instruction?
No, Lordship, the notice was not, notice has not been served to me, Lordship. I am here, the main party here, Lordship, effective order, day 6.
My lord, we'll give the notice. I am on some other points also, my lord. We are not affecting.
Let him, if he's a party.
No, we'll serve a notice, my lord. No
We'll
problem.
take it up day after, what do you call it, on Monday.
We have 2 more prayers, my lord.
Yes.
My lord, what had happened thereafter, stop construction notice was issued. Eventually, what happened, Your Honor, there was a circle officer report, my lord, which says that we have encroached 3.5 luchas of land. Now, one prayer is that, my lord, the circle officer may be directed to at least demarcate the land. We are in possession of 2 katas of land.
It will
No,
come later.
demarcation will be done, you have to apply before the deputy commissioner
yes,
court
yes,
to,
Lord.
district commissioner's court to do it.
Yes.
High Court can't issue a direction for demarcation.
Now, what had happened, my lord, they say that 3.5 luchas of land has been encroached by us, which is in excess to the 2 katas of land that we are in possession. Now, my lord, that is, we are disputing, my lord. So, to cut short the adjudication of this court, my lord, what we pray,
We give you liberty to move the jurisdictional district commissioner to have the land demarcated, because demarcation is something under the Assam Land and Revenue Regulation. I forgot the provisions, 23, I think. We give you liberty to.
so that in that moment, my lord, then notices may be issued, my lord. There are private respondents as well, my lord, 7 to 11. My lord. We'll take justice service on that, my lord.
Okay, you can give him.
My lord.
Okay.
And one small prayer, my lord, can I make? We had filed one RTI, my lord. The RTI was not completely responded to. So one register is there.
and the original case record of this may be called for.
It will come after hearing also.
My lord, what will happen? That will summarize the case. Where is that? Where is that? My lord, may I take your lordship to page number 219, my lord? This is the RTI we filed, my lord.
Yes.
So after filing of the RTI, my lord, at 221, they replied, my lord. Number one, your question are not understood specifically. This is the answer. And second is the information you sought is present in our office. You can collect the same with a reasonable time. What happened, my lord? Then we accordingly replied, my lord. That is at page number 222, my lord. May I read out page number 222, my lord?
Yes.
In connection to the letter received from your end on 21/2024, without prejudice, it is clarified that undersigned requires the photocopies of the register received and issue register of General Branch maintained at your municipal office. This is what we wanted, my lord. What had happened? Initially, when they replied, my lord, they did not respond that there are some complaints from the local authority. What they state, we have got instructions to stop construction. Now they say that we have got information. There is a difference between instruction and information. So we were specific pleading in the first repetition was that the instructions that they have got is got from some political parties. So ultimately the court rightly set aside that order and they again issued me a notice. Now when they come up with this second notice, my lord, they came up with a reply that some people have given complaints, and that complaint weighs back to March 2023. That was never pleaded, man. So what we wanted, there is a issue register and receiving register at the municipal board, man. What has come to our knowledge. We want that original register because they did not reply to the RTA. We wanted a copy of that register. And secondly, the case record, man. And notice admission. Nothing more.
But Mr. A.K. Saivara, learned counsel for the petitioner. Sir, as per our government advocate appearing for respondent number. For urban development, who appears?
Urban development government.
He will be appearing. Okay. Mr.
One and
government appears for respondent. Let's see. You should notice including notice on the prayer for interim relief. Returnable on, give a fixed date after 4 weeks. 4 weeks will be enough?
Lots.
29 May,
29.
20th?
29th.
This tarikh.
This
29. 29 is 29. 29 day होगा ना this वो date 31 को 30 को 22 तारीख में होगा अपन 30 को दे तेरे मोर अलग टाइम है तो कम 30
is Thursday. Thursday, no.
Make it 31st or any other day. Tuesdays and Thursdays we are reserving for many hearing matters.
31 Lordship.
Please convenience is coming from outside.
20 this
No,
20th Monday.
No, 28.
20.
Yes, 20. No, it will. I will get some time. I will have need some time.
Make it 27th.
27 Lordship. 27. 27. Yes.
5/2024. As Barwar and government advocate accepts notice on behalf of respondent number 1 and 6. Mr. J.K. Goswami and council accepts notice for respondent number 2 and 2, 3, 4, 5. Yes, correct?
Yes.
2, 3, 4, 5.
Lordship.
Oh, 27 there is a division bench. No, 27 there is a division bench notified.
Any other day?
31 Lordship.
We can have a choice because he's coming from outside.
How about whatever the lordship?
Which was the date?
I was suggesting 20th, my lord. If
It will be short for him.
next week, then some other day, my lord.
31st?
May?
Okay, 31, 5. Mr. We visit extra copies of the education we served on them for 2 days. Next.
The petitioner shall take steps to introduce for service of notice on the respondent numbers 7 to 11 by registered postal ID. Then council is at liberty to collect the postal visit number and submit postal track report prior to the next date of listing. Notice including notice and payment.
7 to 11, my lord, I can take by Dasti as well.
Oh, okay.
Private package, we get a complaint.
The petitioner is at liberty to take also take steps for service of notice on the private respondent number 7 to 11 by way of Dasti by routing the process to the registry of the court. And upon service and affidavit of service shall be brought prior to the next listing. Next paragraph. By referring to the RTA query of the petitioner. Let me do to page 219 of the writ petition. It was it that the Sarupatra Municipal Board maintains a register wherein incoming letters and correspondence are received. And although the petitioner has applied for copy of the receipt register from 1/3/2023 to 31/3/2023, the same has not been provided. On the ground that the query of the court, the RTA query of the petitioner could not be understood. Next paragraph. The Sarupatra Municipal Board, you can take a respondent number 2, 3, 4, and 5. They produce a photocopy, we shall produce a photocopy of the receipt, incoming communication receipt register for the period 1/3/2023 to 31/3/2023. Before the court through the runners standing counsel. Next paragraph, this one 31/5/2024. You have capital in the case.
Deeply.
In the second item,
Same, my lord. What had happened, my lord? Initially, they had issued notice for stop construction and then they cancelled so both are challenged on the two days.
your notice has already been issued.
No, this has been issued.
Okay, both sides are represented. In view of order passed and connected WBC 1427 of 2024. List the same along with the said writ petition on 31/5/2024.
Dasti for 7 to 11 months.
No, your notice has already been issued.
No, in first.
It's
Deeply out.
Item 7.
Yes, Mrs. Logia.
I have got a very limited prayer. The petitioner late father was having a plot of land, my lord.
But for demarcation, you have to approach this deputy commissioner's court. Why a writ petition? Writ petition, we can't monitor this.
No, my lord, he has given, nothing has been done, my lord.
Where is your application
But
for?
application, my lord, he is a semi-illiterate, almost illiterate person, didn't.
No, because you see,
really
we don't
copy.
have the jurisdiction. Under 226, we don't ask the court to, the
My lord,
commissioner's court
but
to.
some illegalities is committed in his land, my lord, somebody has, my lord.
Okay, but please
Somebody,
apply for
no, my
demarcation.
lord, unless an order is given, my lord, he will not get justice, because he has
No.
filed so many
We can't
applications.
presume that. You don't apply for
Initially-
demarcation and then you say that you won't get justice. That is,
Initially, my lord, no, he didn't copy of any of the copy application, my lord. So, my lord, if you also call the record.
no, no, no. Mr. Saikia, demarcation process we are not taking up. I will not convert this court into a
How
public
you
of matter.
protect, my lord, it is not the demarcation order. Your lordship can protect how, because in his own land, my lord, copy of the government, you will see, they are having some land, but in my land, they have constructed the house. And therefore, initially on his application, my lord, they stopped the construction of the house. Thereafter again opened, and that is behind his back, he didn't know about it. No information, no hearing, my lord. See, my lord, page 18. Report for stoppage of construction of government funded house. It is to inform you that the above mentioned subject that one so and so has filed an application for stopping of construction illegally made by so and so on the land of the petitioner situated at so and so under village Niransova Moja so and so. As per record, it is found out that land 2 bigha 11 lesa in village Niransova. Rainago 3 kotha of land belongs to Muhammad so and so. The father of the applicant and Ajmani Pattagi. Surgeon and community seen that the Muzammil Hawk so and so is occupying, although he is not having Namjari. It is a disputed land. Initially, it was stopped again and again, including Thana, everywhere he has filed the application. How your lordship will protect my lord? It is up to your lordship, my lord. He's a simple citizen, my lord.
I find it very
Senior
difficult to
citizen.
accept. You come to page 20,
Yes?
page 20,
Yes.
Assamese
Yeah,
version
but-
is,
yes.
Assamese version is 21.
Yes.
So there is already a report of the allotment. There is a surgery report by the allotment about the aforesaid Moja and Dag. It is found that Namjari in the name of father of the applicant as well as complainant. So in view of Ajmali Namjari, Khairullah Sheikh has constructed the house. So if it's a joint pata, somebody makes it, then the only alternative remedy you have is to file a suit.
Yes.
We can't permit
He,
this court
he
to become
don't
a.
have that means, my lord. He's a poor person. Others are
You apply
also
for legal
adults,
aid.
sir. But my lord,
This is
if
Saikia.
your lordship kindly protect his
This is
interest,
Saikia,
my
I'll tell
lord.
you.
Suit is going on, my suit is
You
going
see,
on 14 years.
The government has schemes to give legal aid to people who are who need. There is legal services authority. You can grant.
He'll
You
not
have to
get
apply
justice,
if you
my lord.
if you
Then, my
if
lord,
you.
his land of Chikatha has gone, my lord, because my lord, the
But disputed question of fact, I am not taking up civil suit.
his right is legal right is violated, my lord. Somebody has grabbed his land and the
Mrs.
court
Saikia,
will not protection.
Mrs. Saikia,
Protection.
you may do one thing.
Yes, my lord.
You assume that Mr. Barwa sitting here is for the private respondent. The person who has a Ismaili Patta here. Correct. This respondent number 6. Now, please overcome the disputed question of fact
It
and
is yet to be
no.
occupied, my lord. House is yet to be occupied under
Correct.
construction.
please rewrite a draft order escaping disputed question of fact. And let me see for consideration at 2 o'clock, please come. I'll try to understand how to overcome disputed question of fact. There's a Ajmali Patta without partition. If somebody makes it, what is the right? What happens to the Partition Act? What happens to the jurisdiction of a civil court? Please try to overcome it, write an order. We'll try to see if this disputed question can be overcome. We'll issue notice. Final order, please draft
So,
one.
the Mandal, you know, my lord. Mandals are always, so my lord.
They are always good
responsible
people.
officer, my lord.
They are, you see, for a lawyer,
Circle of-
Mandal is one of the best people. They give employment to so many lawyers in the state of Assam. They are good.
My lord, in village. this
Surf Excel says दाग अच्छे
is-
हैं.
that person, my lord,
Surf Excel says दाग अच्छे हैं.
is only matriculate.
Correct.
So how
2
he
o'clock.
see kotha of land nowadays? It is
We
costly
don't know.
also. Still,
We have a civil court.
If he is not protected, my lord.
We have a civil court. We can't make this court to convert it to a civil court.
But earlier I have done so many cases for demarcation and other things, transport department.
No, you see,
and
this was a
and
law
got
where we
appropriate
had the
order.
jurisdiction. You see, when the act says, not now. Nazir Ahmed laid down in
Yes.
by the Privy Council, what is to be done in accordance with law must be done in that manner and no other manner. So if the land revenue regulation says, please apply for mutation. How can the court under 226 direct that please mutate it, please demarcate it? If we start doing it, then there is no requirement for the government itself. We take over the government.
It can be sent by the legal aid because I am not, my lord, he's known to me for last 30 years.
That's okay.
So my lord, without taking, I have tried to
It's okay.
protect
You see that-
his right. If the
you're
court
not-
is not
if you-
granted, I am helpless. Not the person is helpless petitioner because he's a poor fellow, he cannot engage lawyers and do any case. my lord.
It's okay. You
And
just apply.
officers are
If you-
initially,
if
they
you-
have stopped.
If you meet the criteria, you will get legal aid. Heard, Mrs. S. Anne Saikya, Learned Counsel for the petitions.
Maybe appointed manner in this.
For revenue, we are
Yes,
having,
as doctor.
Mr.
As the top.
S. Datta Learned, standing also for the Revenue Department, appearing for respondent number 1. Mr. S. Bhargava and Government Advocate appearing for respondent number 2, 3,
3, 4, 5.
4, 5. Next one. The case projected by the petitioner is that he is having a plot of land measuring about 3 katha in that number 133, Pata number 1395 at village Niran Chuba, NIRANCHUBA, Moza, Reina Kuchi, RAINAKUCHI, under Patharighat Revenue Circle, PATHARIGHAT, Revenue Circle. Full stop. The said land is inherited from his deceased father. Full stop. It is projected that the respondent number 6 availed PMGAY benefit and forcibly started construction of his house on the lot of land of the petitioner. Full stop. The agreed petitioner approached the circle officer, Patharighat Revenue Circle, for stopping the construction and to take action against the respondent number 6. Full stop. The Sipajar police station was also informed to stop construction. Full stop. Although the circle officer directed the BDO Sipajar block by letter dated 25/7/2022 to stop construction. But the competent authorities released the second and third installment of the PMGAY fund to the respondent number 6. Accordingly, the comment is submitted that not only the construction of the respondent number 6 is going on in full swing, but in the process, the petitioner is deprived of the possession of his land. Stop. Next, accordingly, the by filing this writ petition under Article 226 of the Constitution of India, the petitioner has prayed for a direction upon the respondent authorities to demarcate the land and to restore possession of the land to the petitioner as per the entries made in the land revenue records. Next slide. The learned counsel for the petitioner has submitted that the petitioner belongs to a economically weaker section of the society and is unable to engage counsel. If is relegated to a real alternative remedy. Next part. From the documents appended to this writ petition, it appears from the report of the circle officer, the report of the letter dated 30/8/2023 from the circle officer, Tharighat Revenue Circle, wherein it is mentioned that the what will be the English of Ismaili? Ismaili Pata, it's a joint Pata.
Joint, which is not been partitioned.
Okay, this one is in italics, right? Ismaili, EJMALI, within bracket joint, bracket plus Pata land, which contains and the land revenue records contain mutation in the name of the respondent number 6, namely Khairullah KH. No, sorry. The father of respondent number 6, father of respondent number 6, namely Khairullah KHAIRULLA Sheikh SHEIKH, as well as in the name of the father of the petitioner, namely late Mafizuddin, MAFIZUDDIN Ahmed. And that the respondent and the respondent number 6 has carried out construction having possession over the land. Full stop. Therefore, it is evident that disputed questions of fact relating to the position would arise in this writ petition. Full stop. You see something, we'll show you why we are not entertaining. If we say something, you'll lose your land completely. Show this.
I don't have any means, my lord. I have tried to give some relief, spending from my own pocket.
Oh, that's okay. It's a welcome,
Social,
very welcome
some
gesture,
social responsibility. my lord.
very welcome and benevolent gesture.
Section, my lord.
23.
23, procedure in case of mandate. Yes, my lord, that I know, my lord.
No, you don't know. Having known, you would not have said that.
Forty-five. same settlement rules and procedures for the dispute between the person of different state, the settlement officer.
And I can assure you, 80% of the people present here in the courtroom today would not know this.
My land, your lordship, no, my lord, that Pata se
Read this,
I have
read this.
20 application filed.
You
In
read
spite of that,
this.
Pata has not been
That's why,
separated.
you see, Mrs.
Pata
Saikia,
has not been
I'm
separated.
sorry to say that people don't read this, 23. You read that, you will come to know.
But the revenue officials are not.
No, you return it back.
as you
If you don't want to read, return it back.
I'm reading it, my lord.
Huh.
Himself as which party is in position. He may determine by summary inquiry who is the person's this entitled to position and may put him in position and or refer the dispute to arbitration for decision on marriage and so on and so on. If the dispute is between the settlement holders of different states, this settlement shall after due inquiry so and so so and so so and so. Is that if the dispute is between the you will take Shakti and other thing, settlement officer or circle officer, whoever it is, authorized determine anyone there is.
So long and short of it is that once they do it, they will not demarcate a land which is in possession of third party, and they will demarcate the other remaining land. Second, they will do is that if there is a dispute, they will refer it to arbitration. And therefore, you will be, and therefore you will be relegated into such
The
a,
act of this country is not protecting the rights of the citizens, my lord.
there is a law, rightly or wrongly, there is a law. And that's why I said, I made a statement which may affect the
Lordship will-
credibility of, you see,
Having enough knowledge to
which
give
makes,
the way and give
which
justice
makes
to.
question,
Yes,
which will question
give
the.
justice to the poor
ability.
person.
That's why I'm saying 80% of the lawyers in the room may not have read it.
Is manner too technical manner.
Uh, So therefore, there's no point issuing a direction because it will damage your, whatever you have. Let me say.
Earlier I have done 2 cases regarding demarcation, court has passed out that. One was dispute to transport department.
Moreover, the
As your lordship, please, my lord,
issues relating to
protecting his right.
related to mutation, partition, etc. will also arise, which would require some amount of adjudication. To stop. Next one. This is a rule of prudence or the civil court is the appropriate civil court or the revenue court is the appropriate authority to adjudicate such disputes. And as a rule of prudence, the High Court in exercise of power under Article 226 of the Constitution of India will not enter into and adjudicate disputed questions of fact. Next paragraph. Accordingly, the court is inclined to relegate the petition to approach the jurisdictional civil court or the revenue court and apply for demarcation of the land in accordance with the provisions contained in the Assam Land and Revenue Regulation from 1886. Next one. Having heard the learned counsel for the petitioner that he comes from a economically weaker section of society, the petitioner may be well advised to apply for legal aid from the District Legal Services Authority, if so advised. The aforesaid observation of the record, this requisition stands closed.
Anyway.
Item 8.
Even after 20 times application also, my lord. Here, my lord, DC Kamrup. My lord, I could not get the land demarcated and I have to pay the tax for all the area. So many hearing also took place. Even after my lord, they didn't pass on. Obligement is the condition we are having.
May I please?
You can't entertain this repetition.
Exactly, Lordship.
You can't overstay on the quarter.
He's retired in 2022.
Representation is not permitted. You're out of service, you leave the house.
Okay, I have filed a representation before that. We have lodged. Does it take the?
What they'll dispose of representation? They have given you an eviction notice. After that, why will they give you a hearing? You have to vacate it.
Possibly give me some 15 days time also. I'll file, accommodate with a rented accommodation also, because my house is not complete.
You apply to them for time. If they want.
15 days.
Consideration, give it. For Mr. And
Yeah.
then transfer for this additional. And Mr. R. Govil and its and also for the forest department.
For all the responses.
Appearing for all the respondents. Next for that. The petitioner has superannuated from service. And in course of service, he was last posted at the Assam State Zoo Division. And he was allotted with a government quarter within the zoo campus. Full stop. As he did not vacate the government quarter after superannuation, the petitioner was served with a notice dated 9/4/2024 to vacate the premises. Full stop. The petitioners submitted a representation dated 9/4/2024 before the respondent number 1, which was not disposed of. And accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking a direction upon the respondent authorities to consider his representation and to grant extension of at least 3 months' time to vacate the premises. The government quarter. Full stop. Having superannuated from government service, holding over of the government quarter cannot get a seal or approval from the court. So therefore, the court is not inclined to entertain this writ petition. Full stop. Nonetheless, not nonetheless, be that as it may, it will be open to the respondent number. Who is the authority? DFO?
Yes, DFO allotted.
Respondent 4. So take note of the representation and the disposal of the said representation be communicated to the petitioner. Within 3 working days?
3 working days.
3 working days. Okay. The learned standing counsel for the respondent shall transmit a download copy of this order to the respondent to bring the order to the notice of the said authority.
Publish.
Asking to give them 15 days time.
15 days time.
Item 9.
Please look, sir.
Just a moment.
What's the petitioner here?
Just a moment. Yes, what do you say?
Since as a private respondent is there, the notice to go. No. Otherwise, her representation is there, Lordship, in Annexure 5, page 23.
But how you are agreeing with this death certificate issued to the previous wife?
Lordship, he was as employed, so government employee, so he will get some pensionary benefit, Lordship. So Lordship,
You see, irrespective of a death certificate being issued to the former wife, she will otherwise also get pension because of her child with this with your husband. Even an illegitimate child has got a right to the pensionary benefits. So how do you prevent that?
Lordship,
Only on death she can apply for her son.
Lordship, but in the death certificate, only the name of this second wife was incorporated there. Annexure
Yeah, after
6,
correction of the where is that? Where are the two certificates? Which page?
page, first death certificate was at page 22, Annexure 4.
22.
22, Annexure 4.
Second.
Second was at page 24, Annexure 6.
6. No, they are merely issuing a copy thereof. It's not two death certificates. Certificate is one.
Lordship, in the column of the name, of the wife, there is two name in the Annexure 6. There is two name. First name is Anjali Devi. Second is Vijaya Chaudhary. Name of
Oh.
husband / wife.
This cannot happen.
Two name is here.
Yes, he is right. Is it birth? This cannot happen. There cannot be a two death certificate in one registration number. You see, come to this registration number down below left side, just before date. Registration number is same,
Same.
Yes, sir.
but in same certificate, you can't have two different entries. Something is wrong. We have to issue notice then.
Yes, Lordship.
Okay. Mr.
D. Barua.
D. Barwa, counsel for the petitioner. Mrs. A. Bora.
D. Bora.
D. Bora, and a standing also for the health department, representing respondent numbers 1 and 2.
1 and 2.
Agreed by issuance of two death certificates under same registration number in respect of the husband of the petitioner. One which contains the name of the petitioner and the other which contains name of the petitioner as well as the divorced wife. The present petition has been filed in Article 226 of the Constitution of India. As the Ernest Standing Counsel for the Health Department has accepted notice on behalf of respondent 1 and 2. Requisite extra copies of the petition will served on in course of the day. As per the petitioner shall take steps within 2 days for service of notice on respondent number 3 by registered post with ED. The notice is made returnable on after 5 weeks.
3rd of June.
Next one, the as an interim measure for the second death certificate in respect of the petitioner's husband dated 5/4/2024 within Takara Nature 6. And be subject to further orders that may be passed in this repetition. List on. So,
3rd June. Item 10.
yes,
My
Mr. Babuya.
My lord, this case, my lord, the petitioner before your lordship is a joint venture, my lord. And some fraudulent activity was there, my lord. I lodged an affair as well as I lodged a complaint to the respondent number 3, my lord, but he did not act upon, my lord. And I'm joint venture, my lord. As a result, my lord, all the money deposited in respect of the work, my lord, has been got solved, my lord. For which I filed a writ petition, my lord, for defreezing my account, my lord. There, my lord, affidavit was filed by there, my lord, the contesting party. I came to know, my lord, they have obtained fraudulent.
Oh, this matter I will not take up.
Loss.
I this matter before any other bench will have me. Very clear to Ramazri. We send it to the
No.
agency, especially the matter. This would be report. This one, this before any other bench on Monday. 29.
This is his name. Not Monday, my lord, Wednesday.
Wednesday, 1/5/2024. I cannot take up this matter.
Obvious.
Item 11.
May please. My lord, this case leads to inadequate compensation pursuant to acquisition of land, my lord, under the National Highway Act. At this stage, my lordship may issue.
So you have approached 3G.
No, okay. He has to go, I think.
My lord,
3G.
3G.
Arbitrator, which one?
991.
You have to apply there. We can't
Yes,
entertain this repetition. We close this with liberty to you to approach the
My
arbitration
arbitrator.
authority.
My lord.
Please be satisfied. 3G.
CG 5 sure.
3G 5. There's a designated authority who has to apply for.
That is correct. my lord.
Yes, ma'am. We close this with
I
that
leave it to
liberty.
lordship.
Okay. But Mr. S.K. Talukdar and counsel for the petitioner. And Mr. C. Barwan and the
Correspondent number 2345.
first writes her name, Mr. S. Barwan, and you are appearing as CGC. And Mr. S. Barwan and CGC appearing for respondent number 1.
2345.
Mr. C. Barwan and standing counsel for NHAI representing respondent numbers 2.
NHA as well as NHA DCL also.
NHAI and
NHA DCL. And
HIDCL
Fine.
representing respondent numbers 2 to 5. Mr. S. Datar and standing counsel for the revenue department appearing for respondent number 6 and 7. And Mr. S. Barwar and government advocate appearing for respondent number 8, 9, and 10. That's good. And is in receipt payment of insufficient land acquisition compensation in respect of petitioner's land acquired for National Highway. Present petition has been filed under Article 226 of the Constitution of India. Next, it appears from the statements made in the petition that the petitioner is not able the remedy as prescribed under section 3G. 3G capital. Then within bracket 5 of the National Highways Act, comma, which is the year
1956.
56. So, according to this, the petitioner stands close with liberty to the petitioner to approach the said jurisdictional authority and raise all the issues which is and take up all the issues which are raised in this writ petition. So accordingly, this writ petition stands closed without adjudication, granting liberty as indicated above.
Item 12.
No, please, Your Lordship. The petitioner is a lady having a Lordships, the petitioner is a lady having a farming business for last more than 10 years, Lordship. The entire facts of the case has been narrated in a representation, Your Lordships. Annexure 39, Annexure M, Your Lordships. The entire factum of the case, Your Lordships, she has been deprived of her legitimate claim over the loan, Your Lordships. That the respondent bank authority has not yet released her loan despite the all the formality has been completed. Your Lordship,
But in respect of loan, we can't issue a direction in a writ.
Your Lordship,
Give loan to X or Y, there can't be a direction in a writ petition.
But the thing is the representation, Your Lordships, Annexure A, page 39, that has not been considered either.
But you see, it shows the jurisdiction that we can take commercial decisions. Supreme Court has time and again reminded the court not to take up those issues.
But at least the representation.
Who is to get a loan is the prerogative of the authorities.
Yeah, Lordship. But at least the representation may, despite the respondent number 2, government authority has been clarified regarding the sanctioning of the loan to the writ petitioner, sending a proposal. But at least the representation has not been considered either to dispose of or to reject or allow or to reject, Your Lordship. That is my humble prayer. Annexure M, Your Lordship. Whether on several round of visiting to the office, Your Lordships, the petitioner did not get any appropriate relief, either to dispose of or dismiss it. Even if the petition has been dismissed, Your Lordships, the petitioner have not to say, Your Lordships. But the pending the representation for a long time, she has having a loss of a rupees, Your Lordships, and deteriorating his farm, Your Lordships, day by day, Your Lordships. Annexure M, page 39, Your Lordships. She has been invested a huge amount of losses for the purpose of availing the loan. Lordship, the respondent authority may either be dismissed by application, Your Lordship, if she is not been really qualified for the loan, Your Lordship.
But then there's no reputation will lie against this bank. This is not a government bank. It's a private NBFC.
But the government has,
No, let us say that you see this, there are finance companies, XYZ finance company, you want to buy a scooter, motorcycle or a car. There are finance companies, hundreds of finance companies.
the scheme has been routed through the this respondent bank. For the government authority has the scheme has been framed so
Where
that
is-
the lordship.
Where is that?
Lordships, may I lordships, kindly annex L page 38. There is a email has also been sent to the respondent bank, your
No, but
lordships.
where is this? We have to understand the scheme. Where is that
Lordships,
scheme?
annexer, first. First loan she has been availed, your lordship, and annexer C, page 22.
No, that's okay. That's why I'm asking you this question.
Lordship.
Supposing X wants to purchase a car or a scooter. His, the seller, let us say X Scooters Limited, they forward a recommendation to X finance company. Now, this X finance company, on receipt of this, is it mandated or directly, is obliged to give you a loan? And can we issue a direction on the NBFC to give a loan to you?
But in view of the scheme, your lordship, annexer C, your lordship, the first loan.
Page.
Annexer 22. First loan she has been obtained. But due to your lordships, the Assam Livestock and Poultry Corporation has been sent to the letter to the branch manager. She has been obtained this loan, first loan, your lordship. But the deprivation of the claiming of the subsidy amount, the respondent bank authority.
Okay, we should notice them. What is your instruction? Do you have any instructions?
For respondent number 1, lordship.
Veterinary
The
department?
veterinary department. No, so we have
So
no
why
instruction
this
in-
veterinary department give it to them, to this small finance bank?
No, lordship, no such document is annexed here, lordship. Only the annexure C and annexure F, they have given, that is the Assam
Whatever,
Livestock and
you
Poultry
issue a
Development.
recommendation. There must be some scheme you have to tell us.
And annexer F is also page 27 only. Subsequent. Page
24,
27, annexer F, your lordships.
27.
Lordships. There's a second the second loan, your
It is
lordship.
from Assam Livestock and Poultry Development Corporation, lordship, and respondent number 2, lordship.
Veterinary number damage. Veterinary number. Veterinary number. Anyone has the.
Yes, 1 week time may be allowed, lordship. I will take the instruction whether a department has issued any such proposal or not, lordship.
No, because you are nothing but your department. If you read this annexure F which you have shown
Yes, lordship.
at page 27, you don't take responsibility of anything. Read this letter, you take no responsibility.
Annexure F, lordship.
F, please read this.
With reference to the subject cited above, I would like to forward here with a project proposal of human bidding function only for the development under NLM, Entrepreneurship Development Program Submission Livestock Development Scheme of Ministry of Age and Dairy Development, Government of India through SIDBI for your necessary action as per the bank's norms and at
Sole
the sole
discretion.
discretion of the bank.
So sole discretion is that if I recommend someone, please give a loan to X at your sole discretion, he may get a loan, he may not get a loan. So if there is a scheme, then you will say that yes, under this scheme, you are liable to give that loan. That you are not doing. Okay, Vishnu, get us instructions.
Instruction only, Lordship. I will take
When?
instruction within
Tell us a
one.
date. Tell us a date when you can bring it.
Ninth of May, Lordship.
Ninth will
Ninth.
be too long. Make it by sixth.
Lordship, in that case,
Make it by
seventh,
sixth.
Lordship,
Maybe by sixth.
sixth, Lordship.
Mr. H. Barwar, counsel for the petitioner is present. Ms.
MM Kotoki,
M.M. Kotoki, learned standing counsel for the veterinary department, appearing for responding over one. Sure. Plain instructions with regard to the with regard to the document appended to this petition under as annexure C and F respectively. List in the motion column on 6/1/2020, 6/5/2024.
Obliged, Lordship.
13.
May I please, Lordship? Here in this case, Lordship, the petitioner is agreed for not granting mutation.
Mr. Barwa, in respect of the last case, I will just in the last case was a case of bank finance. Please contact the district commissioner in any place where you are comfortable, and please ask them to give you for the court purpose. They have earlier times. I'm speaking this, I'm saying about 20 years back. There would be a monthly meeting with the district commissioner and the banks for the purposes of loans under government scheme. So there were regular meetings held. I'm not aware of the present situation. Please try to find out if still that is carried out, because government scheme finance is being recommended by the district commissioners for various schemes. Earlier they used to have those meetings where they chalk out a plan for the citizens to avail hassle-free loan from the banks.
So there is a coordinated effort between the district administration and the banks.
And the banks.
So that the loans can be easily disbursed.
Yes, they used to have meetings earlier. This I am speaking of my experience 20 years back.
So what is then the coordinated?
Presently, it is whether that coordination is going on or not. Please find out.
By when Lordship would require?
We just get it whenever we get it. Since that repetition came, it suddenly occurred to me that there may be an answer there.
I will definitely.
We are fixing that matter on 6th. Try to get it if they can. Because this is election time, you may not get the adequate instructions right
I
now.
can also have an information with the bank official also, they will be in a better, also.
Okay, District Commissioner, we'll tell you whether this meeting is going on, that means the scheme is still operating. Then I'm partly aware of the scheme. Yes, Mr. Khan.
But not here the grievances of the petitioner is there. He has purchased some land, Lordship, and thereafter, Lordship, application was filed for mutation.
Mutation, you see, these are, you have to move the department.
My lord,
How can we entertain these mutation applications?
my lord, under similar circumstances, another person, Lordship, he has purchased the land from the same number, same partner number, and he has raised the similar grievances before this honorable court. And this honorable court has disposed of this writ petition, directing the deputy commissioner to grant mutation. Accordingly, mutation has been granted. That is page 47. And only difference is some dates and date of the registration, sale date and date of application.
Where is your application for mutation?
My lord, that is application, Lordship, is at page 18, Lordship.
So along with all necessary documents I place.
Where is that? Which page?
Page 18 onwards,
18.
18 onwards. Series of documents,
No, you show this application of invitation. Where is that?
that is page 18. And prescribed format, page 20 onwards. Page 22 is the prescribed format. Now lordship mutation is become a notified service under Assam Right to Public Service.
No. This is a special grant, FC grant land.
And
Are you aware of the power of transfer of the grant lands? Where is the land document?
my lord, the registered sale deed lordship that I have annexed. Page 11 lordship.
Given.
And the permission of the DC is page 16.
No, not this. You have a Jamadi of this grant?
My lord, yes, the seller Jamabandi lordship, that is page 45. 46 is the lordship. Article.
Okay, kind of will issue a notice. Tell us about the grant land. Heard Mr. Handler and Council to the petitioner. Mr. S. Dattar and his standing counsel for the Revenue Department appearing for respondent number 1. And Mr. S. Barwar and the government advocate appearing for respondent numbers 2, 3, and 4. Issue notice returnable on in 4 weeks. requisite extra copies of the regulation to serve on the relevant state and departmental council in process review. Pendency of this regulation shall not be brought to the concerned respondent number 3. To mutate the land in favor, land in question in favor of the petitioner. List of votes. Obliged. They can come back.
Item 14.
May please. Petitioner's case is that.
I've just addressed the bar. I've just received a message that Honorable Former Justice P.K. Saikia is expired. I've just received message right now. One of the finest gentlemen.
Yes. Justice P.K.
You are issuing notice in this matter.
Lordship, yes. Lordship, that notification has been already received by the department. Lordship.
No, we know that. Yesterday also we issued notice.
Lordship.
We bring it on record.
Yes, sir, yes. Yes.
Because you'll have to take a stand. The right accrued prior to this.
Lordship.
That's why you wanted to see this. The right accrued prior to this. Whether that can be taken away. That's the only reason we are issuing notice. But Mr.
I am in Lordship.
I
Amin.
mean, then counsel for the petitioner. That's correct. Claiming
Another similar situated case is pending.
the petitioner is the father. Yes, the petitioner is the petitioner number 1. Sorry, the petitioner number 1. He was the father of the petitioner numbers 2 and 3. He's stated to have died in COVID-19 pandemic while performing his duty on 15/9/2020. And accordingly, the petitioner has applied for compensation for ex gratia payment in terms of the notifications issued by the government of Assam. And accordingly, owing to non-receipt of such ex gratia, presented petition has been filed under Article 226 of the Constitution of India. Next paragraph. Says that the net stand counsel for the Revenue Department accepts notice on behalf of respondent number 1. And this as Balwar and government delegate accepts notice on behalf of respondent numbers 2 to 5. Formal notice may not be issued. However, if visit extra copies of the application is done in the course of the day. That's correct. The learned Standing counsel for the Revenue Department has produced a copy of notification dated 13/7/2023. To project that notifications of the OM dated 2/9/2020 from 8/10/2020 and and another notification of 8/10/2020 were both withdrawn. Next, be that as it may, the stand of the respondents will be brought on record by way of affidavit and all in written instructions. Next, the pendency of this representation shall not be a bar for the respondent authorities to examine the claim of the petitioners. List of the 4 weeks.
Lordship, another matter, Lordship, WPC number 2176, similar situated case.
Unless we are not clubbing matters.
15.
May I please, Lordship? Lordship, similar matters have come up before your Lordship. There is a similar order at page 82, Lordship, passed by this court.
You have participated in the proceedings?
Lordship.
Final order has been passed.
I have participated, final order has been passed, Lordship.
Final order has been passed.
Yes, Lordship.
Okay, so same, it will be same.
Yes, Lordship. Paragraph 4, Lordship, that was related to state case, so that might be omitted, Lordship.
Para
4.
Okay. Page. Same order, page 83. Para 4 omit.
Order date is 11/3/2024, Lordship.
Just a moment. Where?
Para 7, Lordship.
Para 7.
11/3/2024.
So para 7, date will be
11/3/2024.
11/3/2024. Same.
And only the returnable date.
Returnable date will be when?
Up to 4 weeks.
4 weeks. Extra copies.
Obliged, Lordship.
You are appearing from?
Union of one.
Union of India.
One, my lord.
Your name?
P.S. Bhattacharya.
P.S.
Bhattacharya.
Bhattacharya. CGC for respondent of 1. Okay.
16.
And CPR. CGST. Yes, Mr. Devi.
Yes, Lordship. We were granted the mutation in the year 2014 in the name of Tamulpur Block Committee, Your Lordship.
Sir, for applicable orders under 147. Cancellation of mutation.
Yes, Your Lordship.
They're
My
all
only
sub-
grievance is, Your Lordship, the entire exercise was conducted at the behest of the respondent number 3, that is the Joint Secretary Revenue, BTC, Your Lordship, and not the Deputy Commissioner. And the persons who are aggrieved, that is respondent number 7, 8, and 9, 6, 7, 8, and 9, they ought to have approached the Revenue Board, Your Lordship. And that too in a period of 3 years, that they have not done. Your Lordship may kindly peruse the page 45.
You see, those orders are again subject to challenge of the Board of Revenue.
Yes.
How can the High Court entertain? This will be disputed questions of facts.
True, Your Lordship, I'm not on that, Your Lordship. The only thing, Your Lordship, is that my mutation was cancelled, and after cancellation of the mutation, they are now, Your Lordship, at para 14, I made a categorical statement that they are trying to evict me, Your Lordship. The respondent number 3, Your Lordship, Joint Secretary Revenue ought not to have directed, Your Lordship, and the
circle officer became functus officio, your lordship, in my respectful submission. He could not have set aside the order, your lordship. 70/2024.
No, you see this,
Page
those,
46.
in RA cases, the same authority hasn't, has power to pass orders,
Yes, your lordship.
and then it goes for a bill. And then it goes for Board of Revenue.
Yes, your lordship. There was no order passed by the deputy commissioner. There was nothing, your lordship. It was only on the direction of the joint secretary revenue.
Where is that order?
Yeah, this is paragraph, sorry, page 46, your lordship.
46.
Prior to that, your lordship may kindly peruse page
Just
45.
just a minute. 46. You are Mr. Chaudhary, you are appearing for BTC.
Yes, ma'am.
Is this land revenue a transfer matter?
Yes, ma'am.
So who is the authority to look after this revenue matters in BTC?
Lordship, here the council head of the department, it will be joint secretary or secretary, Lordship, revenue.
Which page you are showing us?
Page 45, your lordship.
45.
May I read, your lordship? With reference to subject cited above. And then page 46 is the order, your lordship.
Who is the authority, Mr. Chaudhary?
Yes, ma'am.
If this joint secretary is the authority, then the petitioner should have been heard.
Lordship, it appears in page 44, the circle officer had a hearing, Lordship, of the parties.
No, the authority which passes an order, you have to hear. It can't be that the circle officer is hearing it and the joint secretary is passing an order on the basis of report. If he's doing it, he will do it, but he have to hear him.
Yes, ma'am. In that case, Lordship may allow me some time to get the instruction, Lordship.
How much time?
Lordship, since the election there today, two districts were on election, Lordship after 7, Lordship, any day.
But then don't await him, we'll pass the.
Yeah,
the notice and then-
Protection will be granted, your lordship.
Okay.
Give your presence.
Then make it 10th
Yes, ma'am.
or 13th. Let us.
Lordship, let it be on 13, Lordship.
13th, okay. So Mr. T. Devril and counsel for the petitioner. Mr. Petitioners. Mr. A. Bhattacharya, and at standing also for the Revenue Department, appearing for respond number 1. Mr. V. Chaudhary, then at standing also for BTC, appearing for respond number
2, 3, and 5, Lordship.
2, 3, and 5. Mr. S. Barbara, Government Advocate, appearing for respond number 4. Next, and Mr. Chaudhary,
Yes, ma'am.
you have to also tell us. Supposing this order of joint secretary pulls the field for mutations in BTC area,
I'll get it.
then what happens to the provisions for 147 and 141 where there is a specified authority against whose orders appeal can be filed under 147 and thereafter Board of Revenue. What happens in that case in the BTC area?
Yes, Lord, sir.
Because there is no amendment made to the land revenue regulation to incorporate the orders of the joint secretary to be appealable.
Very true. Under the 62 law set.
Therefore, every land dispute will now come to High Court. So we'll have to request the state government to have an amendment made to the, we have to create a forum, because if too many repetitions start piling up for land revenue matters, it will not be only one BDC, it will be other council areas also. NCL's Autonomous Council, Sabi Autonomous Council. It creates a difficulty for the court management. Which is the interim order?
Page 46, your lordship.
But then you have to amend your petition. You're not challenging, if you're not challenging the order of 45.
No, 45 is not the order. 45 is the direction, your lordship. On the basis of the direction, this particular order was passed.
But you cancel, there's a direction. If this remains, we can't stay this 46. You have to implement both. 45 says you cancel it, and therefore the authorities have cancelled it. So this order has to be challenged.
Because it was a later direction, that is why I have not challenged it, your lordship. I have only
No,
challenged.
but whatever is the direction, they implemented this. In the order, they are referring it. As per letter dated 5/3, they are cancelling. If they are cancelling, you better amend it. You amend it and bring it again, we'll take it out on Monday. The general counsel for the petitioner. 6 we give the court to amend the prayer in the petition to sell the directions based on which interim order dated 7/3/2024 was passed. We said corrections. Shall be done by. We can allow him to do it now because this is only a prayer.
Yes, sir. It's only.
Hand we can do it. Yes. So the prayer is allowed. The counsel to the petitioner shall make necessary correction in the petition under his signature. And also make corrections, make similar correction in the copy of the.
Lordship, the CS procedure is there by, it may be.
No, not for the contents. CS is only for the cost title.
Yes.
Similar corrections shall also be done in the copies of the petition furnished to the Damage State and Department of the Council under his signature. Next column.
Okay.
By filing this petition under Article 226 of the Constitution of India, the petitioner has a say. The directions contained in the letter of respondent number
3, your lordship.
3. Dated 5/3/2024. Considers the order dated 7/3/2024 passed by the circle officer
Tamulpur Revenue Circle.
Tamulpur Revenue Circle. Cancelling the invitation of the name of the petitioner in respect to the land in question. And reinstatement of the land of, the name of the former Patazar in the land revenue records. Next petition notice. Including notice of the prayer for interim relief returnable on 13/5/2024. This one. Formal notice is not required in respect of respondent numbers 1 to 5. So, however, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 6 to 9. 5 is supposed to vary. So, the notice is made returnable on. Next, on a projection that the respondent number 3 from Joint Secretary ETC Kuprajhat did not give any opportunity of hearing to the petitioner, and the order dated 5/3/2024 was passed without compliance of principles of natural justice. The court is inclined to suspend the operation of the remark dated 7/3/2024 entered in the Jamabandi under serial number CHA in respect of Pata number 136 within bracket new of village Bareigaon, BAREIGAON, Mozapur, Baksa, PUB, BAKSA. In bracket annexure 10, Roman 10. Is the next date of listing. Next, the petitioner is permitted to petitioners are permitted to produce a certified copy of this order before the respondent number 2 and 5. The 3 and 5. Bring the order to the notice of the said authorities.
I'm deeply obliged, Your Lordship.
List on 13/5. Okay, the name of GSM. And the the causes by listing the matter next.
Lordship, extra copy. Extra copy.
Pardon me?
Lordship, extra.
I will.
Just mention extra copies. I already mentioned that.
Yes.
Deeply obliged.
In case of date, because otherwise you will not get instructions.
Item 17 for order implement of party.
Made picture.
Yes.
My lord.
Who is
My lord,
who is this party sought to be implemented?
my lord, the wife of, actually I'm the wife. My husband bought this garden, my lord. There are two gardens. One is, my lord, Lahorijan Tea Estate and other is Nirmal Tea Estate. My husband purchased it from my lord, owner called Hanuman Tea Estate, tea company. Now, my lord, what had happened?
Because of this litigation, my lord, I have lost my husband in mysterious circumstances. I lost my elder son, I lost my second son. Now, my lord, this Karbi Anglong authorities, my lord, they are playing hide and seek in this case. My lord, there is already a judgment, there's a contempt matter which is before lordships today. The mutation order, they are not passing on one pretext or the other. The contempt matter is also there. Now, my lord, this gentleman call is a person from Nagaland, my lord. He under any circumstance, he cannot buy property in Karbi Anglong. Now, he wants to show that he is also owner of the tea estate. What be that as it may, my lord. He has filed a writ petition where he is seeking certain direction without making me a party.
Oh, you are the,
I'm the owner, my lord. Even the factory license and all are in our name, my lord.
yes. You are appealing for the.
Lordship, I'm the writ petitioner,
petitioner?
Lordship.
Ah.
Lordship, in this writ petition, Lordship, the challenge is that, Lordship, some portion of land of 2 tea gardens, where Lordship, this writ petitioner, Lordship, claims to be the owner of those two gardens. Some illegal encroachment has been, Lordship, encroaching the land. Accordingly, Lordship, this writ petitioner submitted several representations before the concerned authority to stop the, Lordship, those illegal encroachments. That has not been considered yet. Although Lordship, initially it was 2021
Mr.
also.
Kalita, we are interested to know about your objection in impleading.
Objection,
the
Lordship,
applicant.
because the person, Lordship, who has filed this application, he has no interest in this writ petition, Lordship.
Okay, so we'll close this interrogatory application by saying that no adverse orders against the interest of petitioner will be passed.
Lordship, in this writ petition, Lordship.
No, in this writ petition or any writ petition, anywhere his interest is involved.
His interest in the writ petition, his interest is not at all involved, Lordship.
Okay.
Well, her claim is that, sorry, his claim is, my lord, he is the owner of the tea estate. Actually, my lord, there is already an order by this honorable court. Portion
No, that
of
is okay,
the,
but you are protected. Once we give a direction in this application.
yes.
That your interest will not be touched by any authority. Since you are
Yes,
not a
yes,
party.
regarding title, Lordship, yes.
Not only title.
Applicant
any-
claim is title,
Right,
Lordship.
you see, here your prayer is, in this writ petition, is that directing the respondent authority to control and dispose of the representation.
Yes.
This representation may be many things.
Lordship.
So anything concerning the applicant
Yes.
will not be touched by the
Lordship.
authorities
Yes. Lordship,
without hearing me.
without hearing.
Lordship.
Mr. Kalita,
Lordship.
you are giving him more relief than he wants.
In representation, Lordship, only, Lordship, we are seeking to protect
No,
those
that's
land.
okay. That's okay. I can only indicate it is for you to understand.
And in IL, Lordship, they are claiming that only their dispute is, Lordship, regarding title. So in since, Lordship, this court, Lordship, cannot decide
No,
the
that's
title.
okay. That's okay. We don't need a hearing for that.
Yes.
Once you concede to it. Mr. K.N. Chaudhary, the senior counsel, assisted by Mr. D.K. Bora.
Yes.
The counsel for the applicant. Also heard Mr. J. Kalita, the counsel for the opposite party number 1. Within the writ petitioner. Karbi Anglong, you are here. Miss. And can try.
Yes.
Yes, can try. No, sorry. See. Yes, no. Yes, the revenue will be. The chief secretary will be government. And as Barwal and government advocate for the respondent number 1, 5, 6, and 7 in the connected writ petitions. As temporary and standing counsel for KEAC, representing respondent number 2 in the writ petition, and 2 and 3. And Mr. R.K. Talukdar, learned standing counsel for NHIDCL. Respondent number 4 in the writ petition. Next slide. This interlocutory application has been filed for impleading of the applicant as respondent number 8 in the connected WPC 1479 of 2024. Next, the learned senior counsel for the applicant has submitted that the husband of the applicant has purchased 2 tea estates, namely Lahorijan Tea Estate, LAHORIJAN, and Nirmal Kumar Tea Estate. From its erstwhile owners, namely Hanuman Tea Company Limited. Full stop. It is further projected that after we said two tea estates were purchased, comma, the petitioner's husband and 2 sons died under mysterious circumstances. Full stop. The applicant claims her interest in the right title and interest in respect of the assets and properties of these aforesaid 2 tea estates. Full stop. Next para, it is further projected that the applicant had applied for her name to be mutated in respect of the said 2 estates, and it is alleged that for one reason or the other, comma, the concerned land revenue authorities under the Karbi Angalam Autonomous Council have not mutated the name of the petitioner, so applicant, for which he had approached this court by filing a writ petition, and for non-compliance of orders passed therein, comma, a contempt petition being
143 of 2024.
UPC. Please repeat again.
Contempt C number 143 of 2024.
For release pending for disposal before this court. Stop. Hence, comma. Hence, comma, it is submitted that the applicant has an interest to be protected, and therefore he has sought for being impeded. So moreover, it is submitted that some portion of the land has been acquired by NHI DCL, and therefore the issues relating to disbursement of compensation.
And there is a restraint order by the High Court also, not to pay the
and therefore the applicant has claimed towards the receipt or the disbursement of the compensation amount. In this regard, it is submitted that this court by
page 36.
Page
36, my lord.
Order 16/9/2019 passed in WPC 6995 of 2019. Had restrained the concerned authorities from releasing payment of compensation on account of acquisition of the land in question in favor of any party. First of, it is submitted that they said order is still in force. Yeah, this is accordingly it is submitted that the applicant has a interest in connection with the subject matter of WPC 1479 of 2024, and therefore he is a proper and necessary party in the said declaration. Next paragraph. The Learned Counsel for Opposite Party number 1 has strongly opposed the prayer made in this implement application. In this regard, it is submitted that in the writ petition, the reliefs which are sought for by the opposite party number 1, as a writ petitioner, is number 1, to consider and dispose of the representation dated 27/7/2021 and 27/2/2024 in terms of order dated 27/2021 passed in WBC 3329 of 2021. Where is that order? Is it page 39? Isn't it only? Is it page 39?
Page 23.
20?
3, my lord, all the receipt.
Semicolon. Number 2. For directing the respondent authorities to take steps to stop trespass and illegal enforcement over the land of Lahori Jan Tea Estate. I'm writing correct, spelling it right. Lahori Jan Tea Estate and Nirmal Kumar Tea Estate.
Yes.
And for taking measures to protect and safeguard the life of the workers of the said tea garden. Semicolon number 3, to expedite the process of mutation. Hence, comment is submitted that the applicant is not a proper and necessary parties in respect of the relief claimed in the writ petition. Next paragraph. On a perusal of the order dated 27/2021 passed by this court in WPC 3329 of 2021, based on which the pair, one of the pairs referred above is made, contains a specific direction that the respondent therein shall take necessary action only after hearing the affected parties, including the applicant, namely Srimati Ampu AMPHU, NTP GTIPI. At page 26, you'll find that.
Page 26.
Yes, first off.
First paragraph.
Next para. Therefore, the therefore, although we find that the objection made by the learned counsel for the writ petitioner of the opposite party number 1 is not sustainable. Nonetheless, as serious objections has been raised, the court is inclined to further to further direct the respondent numbers two and three, two, 3 and 6, right?
5 and 6.
Six is.
Well,
no,
three,
six
three is the person, my lord, who will.
No. 6 is subdivisional officer. He's under you. This is right?
And lawsuit. 5 and 6.
5 is also.
Yes.
No, deputy commissioner is state. No, they will not do anything.
Lawsuit.
This is a transfer subject.
Basically, my lord, serial number 3, he is the person.
The respondent was 2, 3, and 6. I, the principal secretary to the KAAC, joint secretary within bracket revenue, KAAC, and the subdivisional officer within bracket civil, Bokajan, shall strictly adhere to the directions contained in the order dated 27/2021, passed in WPC 3329 of 2021, and they shall refrain from passing any orders in respect of the land or affairs concerning Lahorijan Tea Estate and Nirmal Kumar Tea Estate without hearing Srimati Amphu, AMPHU, NTP, ENG, TIPI. Next paragraph. As therefore impeding is opposed in this in connection with this interlocutory application, the applicant, namely Srimati Amphi NTP, shall be at liberty to take such steps as may be provided in law to protect her interest.
Deep level.
You were going from fire, jumping from
frying pan to the fire.
She is already protected under this order.
No, you don't know the effect of the order. You will come to know. Once you read this, you will come to know about the effect of the order.
My lord, item number 49 is same, my lord. It's in a contempt matter. So there they have not filed the affidavit. Fine question.
We have not really initiate. You will not be here, ask somebody to be here.
Well.
Ms. Kempe? It's okay. Huh?
I have missed it. I don't know that the lecture came up with it.
No, you are not there in contempt. In contempt, we can't compel you to be to appear. But take note of what is happening. Today we got a sad news.
Some other.
Today we have sad news. Justice PK.
Yes, just now we heard.
I just came to know. I thought you may not.
I think my lord, he is still in Delhi.
He was under treatment at Delhi.
The message we got was he expired at Delhi. Therefore, when the body and all would come. Malman. Right. I also got a WhatsApp message somewhere in our group, my lord. Possibly we can, yes. My lord, I'll just take 1 minute time. I'll give an example of his humility, my lord. Once he was a judge, he was acting as a judge of the Shillong bench. I had a matter. Then I did the matter. Then I came back, I had lunch, then I took the taxi, I was coming to Guwahati. Then a phone call came. I couldn't recognize, he said, "Moi hoikiai koisu." I said, sorry, I'm very sorry, I could not recognize you. Could you kindly explain who are you? Then he said, no, moi hoikiai koisu. Then somehow I could sense, I think it is the voice of Honorable Justice Saikia. Then I said, is it Honorable Justice Saikia? Sir, hoy. He didn't say that I'm Justice Saikia. Something really moved me, man.
No, you have to.
He had some clarification he was wanted to ask me, that's why he called.
In one of the matters, I'll never forget. I argued a matter before him when I was a lawyer then. And I took up issues which has normally civil nature. And I'd done my matter, was going back. The lunchtime, he saw me and then called me for an interaction to understand one aspect which
Your lordships are good.
he could not
Understand.
he could not.
Yes, my lordship. My application is for implement of Pallavi Mandal, the natural mother of the baby Uday Sarkar, as respondent number 7, my lordship. We have and petition WPC 1481.
Just a moment.
1481. Seeking the custody of baby adopted by the petitioners from Pallavi Mandal, one of the near relatives,
We are around here.
who is a single mother of the baby.
This is M. Burman and counsel for the applicant. For government, Ms. S. Baba and the government advocate appearing for respond number 1, 2, 3. This is D. Bora and standing person for respond number 4, 5. The government advocate will also be for 6. Respond number 6 in the connected division. Next one. By filing this interlocutory application, the applicant, who is the red petitioner, is seeking implement of Pallavi Mandal from the natural mother of the baby, the sought to be adopted by the applicant. Full stop. The said period being not objected to stands allowed. The you heard Ms. Amberman saying this. Next, in view of the order passed today in IS Civil 1174 of 2024, impleading of the applicant therein as respondent number 7 is allowed. Next, the Learned Counsel for the petitioner shall provide a amended cost title to the AOJ civil rule pending section within 2 days. On receipt of the same, the central registry shall be amended and the amended cost title shall be incorporated in the liquidation. Next, pending the completion of formalities for implement, issued in notice on the newly integrated respondent number 7 by registered post
with AD, the notice is made returnable on after 4 weeks. So the
29th May.
applicant shall, the petitioner shall take steps within 2 days for service of notice. Within 2 days. After interviewing process is completed for service of notice on respond number 7 by registered postal lady. Next list on
29/5.
9.
29th May.
Oblast, oblast.
Supply item 54 for motion.
Yes, this is that we wanted Mr. Nath here. This is that Lanka Municipal Board.
Yes.
Lordship, Mr. Dinath is appearing in the matter. Let the matter be called after some time. He may be coming only.
55.
After some time.
May I please, Lordship, right to improve Fair Compensation Act, Lordship on last occasion directed us to produce the proceeding that we have drawn out. Lordship, I just giving the extract part of that document, and original files are also with me, madam. Right, Lordship.
Yes.
Lordship, this is the file, original file of the department, and my lord, the abstract part connected to that proceeding which we have drawn out. I have made a compilation of that. The entire proceeding has been drawn out in accordance with law. Time limit we have also maintained, madam.
No.
Well,
That's the difficulty.
but
You see, there has been a judicial interpretation, not only by the Supreme Court, but also by this court, saying that whatever act you apply for the purpose of acquisition, the principles of 2013, that the Right of Fair Compensation Act has to be complied with.
Right.
Now, that is why we, as that last order, you see the impact assessment has not been done. What you did was, at your requisition, the state government invoked 1964 Act, which is the Land Acquisition and Requisition Act,
Right.
and made the assessment. And therefore, the transparency of Land Acquisition Resettlement Act was never followed.
Right.
Therefore, From here, we don't understand that this is under right to fair compensation.
My lord, right to fair compensation, lordship, because make the position, because right to fair
No.
compensation indicates the.
If you see, if right to fair compensation were not taken, adhered to,
Right.
now you are complaining that the limitation of this act would be applied.
My lord.
How it would apply?
My lord, we have followed the footsteps of right to fair compensation because lordship, it indicates that the procedure how to follow that form A, B, C, D, the timely which has to be, my lord, indicated, we have followed, my lord. After notification,
Which document?
lordship can have a look, my lord.
Which document?
My lord, first, lordship kindly see for a moment. The page 4, my lord, this is the starting point.
Yes.
Now, under this, my lord, form A, notice and order, my lord, we have shown our intention towards, my lord, requisition of that land. This was issued on 2/2/2021.
No, please don't show us this Form A. Form A is under the Land Acquisition Act.
My lord, the name is mentioned, my lord.
Assam Land Acquisition Act.
Yes, my
Form
lord.
A.
Power exercise, my lord, under, yes, my lord, Act 1960.
Then your impact assessment were never done. So once the land is acquired under the 1964 Act, please tell us for the purpose of limitation, how this will
My
apply.
lord, there too, my lord, acts
So we can't issue a writ petition, you do whatever you want.
lordship, I need some time, my lord, to get the instruction from the client, my lord. If they want to withdraw, my lord, I will withdraw.
Because then you'll have to challenge the entire process of what is being done.
My lord.
Writ petition in this form would not be maintainable then.
My lord.
Once you subject yourself to jurisdiction.
My lord.
But the problem is that the act would have no application.
My lord.
This Transparency Act, the Right to Fair Compensation Act, it does not envisage a situation where the land was acquired under the Assam 1964.
My lord. After
Assam
2013, my lord, it has no role to play. It has been otherwise repealed, my lord.
No, not repealed. It's not repealed, but there's a judicial interpretation saying that for those purposes also,
My lord.
Transparency Act will have to be applied. So therefore, the impact assessment, all those things, what you call the compensation, will otherwise be assessed under that.
My lord.
And,
That clarification
this is-
also I will get from my.
And this is something which I have dealt with.
My lord.
There's not in this bench, but in outlying bench, I have dealt with this issue extensively.
My lord.
So we adjourn it mainly.
My lord.
Mr. S. Samayan, counsel for the petitioner, has produced certain instructions. So, semi-sketched part of the record. Yeah, one. It's the records produced by him are returned. As per the in respect of the issue, that the acquisition process in this matter was under the Assam Land within bracket Acquisition and Requisition bracket Act from 1964 was invoked. The learned counsel for the petitioner seek some time to obtain instructions. But the matter is adjourned today. List on when?
At 2 weeks. My lord.
Give a date. Because it's
My lord,
motion matter.
because my lord, the election process, they have officers.
Oh, acha, acha.
7th is on the, my lord.
Okay. So make it 13th May. It's
My lord.
motion matter.
That may not be begin because lordship.
Okay, list after 2 weeks.
After 2 weeks.
Okay.
Deeply obliged.
Sorry, my lord, I was not there. My lord, this is against violation of.
Your this order of
My lord, the stay
2022.
was granted. Stay was
What-
granted to the District Legal Service Authority's order, my lord. Where District Legal Service Authority's member, they said that
the petitioner, that is the private respondent in the writ petition, is at liberty to demarcate her land, since the dispute was regarding the demarcation and right title and interest. Now, a stay was granted by this court. She appeared. After she appeared in the writ petition, that I have annexed the copy of the Honorable Court's system printout, my lord, which reflects that she has appeared on 23rd of January 2023. Now, all of these are being carried out by her in connivance with some local goons and political party members and all that. I have no other remedy but to file this contempt petition. I shall be also satisfied if your lordship tags this matter with the writ petition also. I understand that it's a contempt jurisdiction is quite serious, but it is very difficult for me.
No, not even that. You see, this order of District Legal Services Authority,
My lord,
though in compromise, would not be enforceable.
my lord, that there lies the problem. There was never any compromise. I never gave my consent. And that's why this honorable court granted, while issuing notice of motion, stayed the order, my lord. The secretary's order reflects that I never gave my consent. And further, it says that the petitioner, that is the private respondent, she is at liberty to demarcate by taking the help of the authorities. And it was stayed.
What has happened after this order?
What has happened is she appeared, lordship will find at after the stay order from this honorable court, she appeared at annexure 3, page 22. This is the printout of the High Court website case status, my lord. And at page 23, the very last line, the lordship will see that she filed the wakalatnama through her counsel on 23rd of January 2023. After that, she continued all these things, and I preferred an FIR at page 24 before the police officials. The police officials come and go, they try to stop her. But even with the help of local goons, she has been trying to demarcate her land. And the photographs which I have annexed at page 25. Now, certain dates are also reflected in the photographs. There, the boundary has been tried to be demolished, and certain new boundaries have been tried to be erected. All of this is ongoing. I understand the matter is pending before this court, and I do not shy away from it, my lord. I am ready for a final hearing. But this cannot go on, my lord, in the presence of a stay order from this court.
No, the stay is what? That
the secretary's order is
stayed.
Not to demarcate, my lord. Stay means secretary gave the liberty to demarcate. There's a stay order from this court, that means you cannot demarcate.
No. It should be plain and clear. It should not be by inference.
My lord.
Contempt can't be by way of inference.
I understand, my lord. I understand. But I have nowhere else to go, my lord. I cannot file a violation petition in the writ petition, my lord. The only option I had left is to file a contempt.
No, but there is no clarity even when reading this order. It doesn't say that, it merely says that the operation of the order is stayed. I will have to demonstrate from something that despite the stay, it is the demarcation is being done in execution of the order of the permanent Lok Adalat.
Because the permanent Lok Adalat says that you are now at liberty to demarcate. That portion is there in the order, my lord.
No, that whatever this process is going on, what is the record that is going on? You have shown some photograph, but the photograph does not show the land revenue people making the demarcation. So, if it's otherwise otherwise not a action, Despite, by the respondent authorities, despite stay.
My
There
lord,
is a
look at
contempt
the
of-
other way, provided they approach the lot mandal and the circle, the revenue officials, and they go for demarcation, and the demarcation is carried out. Then, my lord, I have to approach the civil court. That will
Even
be
here
the
you will
only
have to
remedy
approach
I'll
the
have
civil
left,
court.
even after filing a
Even
contempt
here
petition.
you will
My
have to
lord,
approach the civil court because this is a inter-party dispute. As to what is the, somebody is encroaching upon your land, somebody is demarcating it. It's an independent action. It can't be said to be, what you call an exercise within the
But
local
I
level
approached-
jurisdiction.
My lord, the only prayer in the writ petition was that the only grievance which I had against the order of the secretary was that against the demarcation part, without my consent. And that was stayed by this court. And that's why now again, if she is trying repeatedly to do all these things, my lord,
Demarcation, you see, demarcation, who will do a demarcation? If X and Y goes to a land, start measuring it, is it demarcation?
no.
Then demarcation must be by an authority who's empowered by law under the Assam Land Revenue Regulation to do it.
But again, she has been successful in changing the character of the land. The existing boundaries have been.
That is not a part of the injunction. That is not a part of an injunction.
May I pray, my lord, if my lord is reluctant to issue notice, my lord, let this come, let notice not be issued, but let this be listed along with the writ petition. And I'm not shying away from a hearing. My lord.
Okay. On the prayer made by Mr. P. Bharadwaj, Land Counsel for the petitioner, list this matter along with connected WPC
4754
of 2022.
Obliged.
Production is item 1.
Production list item 1.
I am appearing on behalf of Mr. Mashidho as both of them. There is a correction in the order.
Mr. D. Gogoi, Land Counsel for the applicant. Is Bharadwaj appearing for the
A Gayan will appear in this matter.
Huh?
That's it. A Gayan. She is there.
Then she is appearing for the opposite party numbers 1 to 4. You have informed Mr. Boro of listing of the matter.
Yes, well, I have informed apart from my lord. Now he did not pick up the call, my lord.
Next, the learned counsel to the petitioner submits that he has given a message to Mr. A. Boro, learned counsel for the opposite number 5 of listing of this matter. How is not, he does not appear in call. Next, this interlocutory application has been filed for correction of date of 18/9/2020 mentioned in paragraph 12 of the order dated 8/4/2024 passed in WPC. So in IS Civil 3792 of 2023 in connected WPC 5427 of 2023. Next one. It is submitted that an interim order was passed in WPC 5427 of 2023 on 18/9/2023, which is incorrectly typed as 18/9/2020 in paragraph 12 of the order of the court. Next one. In view of the clerical error, clerical of the typing error which is kept in the in paragraph 12 of the said order, comma, this interlocutory application stands allowed. First, the date 18/9/2020 appearing in paragraph 12 can now be read as 18/9/2023. First, this order shall be read together with order dated 8/4/2024 passed by this court in highest civil 3792 of 2023. This is sense disposal.
Being item number 54. Please, your lordship.
Yes.
My lord, he's on legs. I'll just inform him. He will be coming.
Okay. Twenty
20 to 22 for admission.
Lordship, perhaps James,
21 million. Is it regarding Bajar Bita आप लोगों का भैया और last
That is connected matter. Just wait for some
connected
time.
matter, Lordship.
Connected.
Just wait for some time. Let us not come.
It's not going to come.
I'll just inform him.
'23.
Please, your lordship. My lord, the petitioner is the president of the number 9 Pukpaka Gaon Panchayat, Bajali, my lord. Earlier, she had been removed from the post of president by no confidence motion was brought against her. So that she had challenged in earlier writ petition, my lord. And this honorable court has interfered with that order, and as per the honorable court's direction, my lord, she was allowed to resume her charge, my lord, at page 66, my lord.
66.
66, my lord. With reference to the subject cited above and as per minus of the.
Just a minute.
Yes, ma'am.
Yes, we are waiting for registrar of this PNRD.
PNRD has the panel of defense. Names have been reflected. Private respondent also appears here.
No, they are in support of the petitioner.
My lord, here we have challenged, my lord, one notice, my lord, on the same day where when she resumed her duty, my lord, a notice was issued by respondent number 9. Your lordship may kindly see.
PNRD. Let someone be there from PNRD. Let's see PNRD. Wait for some time.
24.
Lordship, as per last court order, I directed the produce some record.
Then we keep it pending for some time. You have received part of.
No, my Lordship, I will.
You have received part amount.
Oh, yes, yes, he has received. Lordship.
Actually, we received a land value, my lord.
It's okay. They are saying that the government has not released.
Lordship.
We'll keep it pending then.
Lordship.
Uh, outside the represented, Mr. Aranda, pending also for the
NCL's autonomous.
NCL's Autonomous Council has produced set of instructions along with forwarding letter dated 23/4/2024 stating that the petitioner has been paid a sum of rupees 5,17,155 by depositing it in his SBI account. Full stop. It is further stated that the land development cost amounting to rupees 4,500 for land measuring 3 lessers at the rate of 1,50,000 per bigha would not be paid as the amount was not released by the government of Assam. That's in view of the instructions of the magistrate judge today, list after 4 weeks. It's only 4,500 rupees.
No, our claim is, my lord, different, my lord.
No, we don't know because that you'll have to.
There is a stone house, my lord.
That you'll have to take another process.
Okay.
Here, you have been paid everything except this 4,500.
Yes.
Our thing is, my lord, your lordship has directed earlier, my lord, to take the photograph of those they are going to dismantle. Our thing is that they have not done that.
No, but that's something we can't do in this rate petition.
Gotcha.
Can we make an assessment of the value of land in a rate petition?
Because the right to fair compensation act was strictly not applied. Yeah,
No, you may know, but I do not know. So therefore, I can't adjudicate.
that will be taken out for 4 weeks.
Huh. But in the meantime, if you wait, we are asking you because of a reason. If you wait,
yes,
then your limitation to challenge would have gone.
Yes.
You think of something, you can't say anything.
26.
My lordship.
Yes, Mr. Barua.
Yes.
I think in such matters, it will be the government who will take a decision.
We have filed our affidavit, so the, our affidavit is very clear as regard the dark which has been ceiling surplus, which has been allotted to gas grid. And the other dark, that is the other, dark 369. That is given to the gas grid and the other and our 370. So if your lordship goes and puts up running page 40 of my affidavit. So I have made it very clear. In fact, on the last occasion, petition was, he wanted to have a reply to what we have submitted.
40.
40.
No, that's not what I'm asking you.
Yes.
No, how will the court decide who is more competent to have the land allotted? What is the mechanism available with the court? Decide who has a better claim for land allotment. It will be the government only who can decide. Even if you adjudicate, what will you adjudicate? Right of X versus right of Y to have a land allotted.
Because these are the public sector undertakings, so his priority has been given for.
That's okay, but legality, how can you examine? Yes, Mr. Upadhyay, how will you examine this legality?
Legally, my lord, I have got the Khatian, your lordship will be certified copy that I have annexed here, the certified copy also. The lordship make it. My father was a tenant in respect of the land in Cochin, that is 370. That has been allotted. This is a Rayati Khatian matter. Earlier it was a Pata land matter of the company and as acquired under the provision of the Ceiling Act.
You see, expressing we have doubt on the Khatian.
Yes.
No, my lord.
The reason being that you see it's a tea state land.
No, Khatian was issued, my lord.
No. Issued is okay. Tell us, I'm asking you a question to make a response.
Let
You
us
see, our
examine
question
whether
is-
it is a genuine or not. Let them examine.
No. You tell us we are asking a question. Let me complete my question, then you'll answer, then we'll be able to answer. You see, this is a land of the tea estate.
It was a land of
Tea estate lands are special grant lands. In special grant land, there can't be a Khatian.
Yes.
No, Khatian was issued by the
That's okay. I'm also surprised it is issued.
No, it was a patta land here. Lordship will,
Couldn't
yeah,
be
it is written here.
a land of,
It was
land
a
of,
patta land. It was a ceiling sub, other, if necessary, I shall show the other documents. It was acquired, there was a formal acquisition. Not a, it was a patta land. Pattadar of Nam. That is the name of the Pattadar. It was a patta land.
what is in the patta number?
Where is the patta number? Yep.
Because in
Okay,
this document which I am reading,
Yeah, number 1. I have also given the sealing case also, otherwise there would not be sealing case. I have given the sealing case also.
you see, this is, it is. It is,
Madam.
free ceiling grant. You see the Assamese version. PC,
Fee simple.
free simple grant. But
It is a
Finland can't be a simple
There are
grant.
various type of Nispi Kheraj, Nispi Kheraj.
But you see, FC grant is, it's ultimately a tea land. It's a special cultivation under the some land and area regulation.
Absolutely.
So if it's a FC grant land for special cultivation, there can't be a khatian on it.
No, my lord.
Because tea land is not for agriculture. Tea land is for special cultivation. You can't be doing agriculture there in the tea garden land.
You have the sealing case, my lord.
You'll have to irrigate, you have to do agriculture for having a tenancy right. How can you have the tenancy right in the tea garden land?
Don't know, my lord. It was tenancy right was created.
How? Which land, under which land there can be a tenancy created? Grant land, you don't know, you have to tell us.
My lord, there is another case also, it's in, my lord, where the notice was served upon the tenant and they challenged. It is also another case in which I have submitted the some other documents in another case.
Because primarily you have to show for the purpose of khatian that it was an agricultural land, he was doing agriculture and
It is
therefore.
it is agricultural land. No,
Tea is not an agriculture, tea is a
earlier it
plantation.
was a tea, yes.
Tea is a plantation,
Tea
it's not
garden,
an
it was
agriculture.
earlier tea garden land, but subsequently, well, during that period, we acquired the tenancy right. We were the cultivator. My father was the cultivator and he was granted the khatia.
That's what we are asking you.
So your lordship query is that the whether a tenancy right can be created in the PC.
You see, for an agriculture, it must be a low-lying land where you can do agriculture. Haritoli.
Oh my lord.
How in a tea land you can do agriculture? Because you see, the tea land by nature is terrain which is unique to tea garden. It's not a low-lying land. Agriculture in a highland, we don't know if it can be done.
It is agriculture land.
It's a tea, you say first it is a tea garden land, then you say it's an agricultural land.
Not agri. My lord, agriculture, your lordship knows very well.
We are not satisfied.
Agriculture land are people
You take it up
purchase-
some other day, you'll be prepared. Yes, Mr. Roy, you are appearing, you have any idea?
So far, my lord, this is the.
So nowadays you do agriculture.
No, the state has filed the affidavit, lordship is seeing para 2, my lord.
What is
Para
para
4,
two?
para 4.
Which affidavit of?
This is page
Page
40,
number
ma'am.
62, of the deputy
Page
commissioner.
number 62.
Page 40, ma'am.
40?
40, serial number.
00. Para?
Para 4.
Para 4.
Para 4 is denied.
Yes.
Yes.
So what you have denied?
That state, my lord, they have denied that the deponent begs to state that the total land covered by DAG number 350, 370, 38, 49, and 48 of village West Dalgaon, Moja West Dalgaon, district Darang is found as ceiling government land as per records. It is stated that no records of Khatian number 122 annexure B to the registration are found in the office of the Dalgaon Revenue Circle. Further, in the land records of the office of the Dalgaon Revenue Circle.
That is something which the revenue will only will tell, be able to tell.
That's what.
It was issued from the office of the deputy commissioner. Or Khatian are in the office of deputy commissioner.
Oh, those things are very.
Dalgaon Revenue Circle may not
In
have.
fact, the name of the petitioners or his father were not found in the riot.
The highest number of arrests in the state of Assam last year, the highest number of arrests made in the government employees in last year, highest people arrested were Lat Mandals.
Black Monday.
Single largest number of government servants arrested is Lat Mandals.
No, in the Sita,
No, that's okay.
yes, in the Sita, there is a name.
No, I'm not saying in this case your Lat Mandal was arrested. I'm just saying that last year,
Yeah.
highest number of government servants arrested was Lat Mandal.
Latman.
So we have a general impression of what Lat Mandal is.
Most powerful, my lord. Black Monday.
No longer.
No, they are. Yes, they are. What did the revenue say?
Revenue is not a party, my lord.
You get the only that instructions have to be what you call the backdrop of this land. You make a specific query.
Yes.
Respond to that. You are referring to paragraph, the respond number 5 affidavit, Mr. Roy?
My third.
I'm 5. But paragraph 4 says nothing, it's statement government.
No, Lordship, it is respondent 2 and 4.
I'm referring to state affidavit, my lord.
2 and 4.
Para 4, page 40.
Respondent 2 and 4, that's right.
That is serial number 40, my lord.
Not 40, 60.
No.
That is my.
Not 40.
Market 40.
2 and 4, paragraph 4. Put in page 62.
That affidavit filed by respondent number 2 and 4, my lord.
This is district deputy commissioner.
Yes.
Additional deputy commissioner.
So your what you call, if it is not there, then your document is to be investigated.
He categorically stated they are not in the office of Dalgaon Revenue Circle. It was issued from the office of deputy. Here, Lordship may see this.
Pass it on.
Yes.
Same document. No, one annex position.
Annex position.
Full number B.
Yes.
No. This certified copy is issued by Deputy Commissioner Darang.
Yes.
And these additional deputy commissioners, these records are not there.
Let them examine whether it is a genuine or not. If it is not genuine, then my case will go. My case is based on that document.
Just give a slip of your numbers, what you call the respondent numbers, registered name, copy will be ordered. That's been so. You give a photocopy of this to,
Yes, I have
Revenue-
annexed that.
Already this is part of the record, I suppose.
Part of the-
Annex a B,
Annex B, okay.
yes, of the rate petition.
Page number 25.
Okay.
Hope that document tallies with the one which has been enclosed.
Yes, yes. It does.
Page 2.
That is a bad habit I have already developed. Uh, While Mr. P. Upadhyay, I'm counsel for the petitioner. By referring to Annexure B to the writ petition, this is a copy of Khatian. Has stated that the the father of the petitioner was a recorded tenant within bracket Khatian holder bracket close in respect of land measuring 14 bigha 4 katha covered by FC Patta number 1. No, sorry, first by that numbers 350, 370, 38, 49, and 48 of FC Patta number 1 of village West Dalgaon, DALGAON, Moza, Duliapara, DULIAPARA grant in the district of Darang. And was allotted Khatian number 122 of the year 1971. He is submitted that the petitioner has a certified copy of the said Khatian, a copy of which is annexed as Annexure B. Next, on the other hand, Mr. J. Royal and a senior counsel, assisted by Mr. Roy. Name?
BP Sharma.
BP Sharma. Done counsel for respondent numbers.
5.
The respondent number 5 has referred to the affidavit in opposition filed by respondent numbers 2 and 4. I.e. District Commissioner Darang and Circle Officer, Darang Revenue Circle. On 23/11/2023, whereby the additional district commissioner, Darang, has specifically stated that the total land covered by DAG number 350, 370, 38, 49 and 48 of village West Dalgaon, Moza West Dalgaon, district Dharan is found as sealing government land as per records. And there are no records of Khatia number 122 within bracket annexure B to the writ petition in the office of the Dalgaon Revenue Circle. Yes, Mr. Bhattacharya. Oh, अच्छा, yes, sir. Deputy Commissioner will be you, Mr. Barwa. Now, how to ascertain? Because there is a specific denial. I can't direct a denial to be proved. But the records will be only with you, with the Deputy Commissioner.
But already we have stated that it's not there. Nine.
The former. The District Commissioner from Mangalday shall cause an inquiry as regards the genuineness of document annexed to the writ petition as Annexure B. And submit a report. And cause a report to be submitted by 27/5/2024. List one 29/5/2024.
In fact, as regard that Annexure B, so already we have made it very clear that we don't have any record.
No, question of record is not there. You see, somebody is
while
producing a
inspecting,
certified copy.
Yes.
Genuineness of certified copy is inherent under section 76 of the
Yes,
Evidence
yes,
Act.
yes.
Therefore, if you have to deny it, then you have to tell us that this is a fake document.
Through an expert.
Otherwise, this is a certified copy. He is producing it, but you take a photograph in your mobile, or Mr. Upadhyay, please give me a photocopy, because in your photocopy, this last line is,
I shall have.
last line is not there.
Yes, sir. I shall be.
So this Dharan Mangalday is not there.
Yes,
At least in my, the copy next to the writ petition is not there.
I shall give.
And this
Yes.
Biju Kumar Boro, below that there is a Pratilipi Karak. That's also not available.
Yes,
in
yes,
the
yes,
copy.
yes.
Next, Mr. S. Barwar and the government advocate shall transmit a downloaded copy of this order to the district commissioner. Udaraj Mangaldev. Next list on 29, 5 and 24. Because Mr. Kalita, they will say that they is not correct. That's why we are closing that.
Absolutely. That will be fair. That will be fair for him also. And one thing, if there is no record, how then he could get the certified copy?
That's why he will say about the genuineness.
Yes, sir. Correct.
Your question, you have, that means, you see, Mr. Rai. Now, this authority who gave this affidavit says that this is not there. And he is referring to Annexure B. Was it not required of him to say that this is not there, this is fake? But he doesn't say so.
Right, right. He was not specific. This would have been specific.
He writes Exhibit B. So if he is referring to Exhibit B, he is not denying its correctness.
Denied Exhibit B. Exhibit B.
So therefore, we don't know what wisdom was there with him. Okay, item 27.
27 with 28.
May I please, Your Lordship, in this case, my lord.
You got instructions?
27.
Government was to give instructions. This is all that ex gratia
Yes or
matter.
no, my lord?
Where is your application?
My lord,
Which page?
okay, that page 23, my lord. 23 and 24, my lord.
Where is the statement that you have not applied for claim under Motor Vehicles Act?
My lord, that statement is not there, my lord, because it is totally different, my lord, in case, my lord. Already a notification, government notification, my lord, it has been filed, my lord.
No, we are not going by that. Even if it is there, we'll be interpreting it. If you have not made a statement, then we take adverse opinion against you.
My lord, notification that page 25, my lord. It is issued by the Disaster Management Department, my lord, Government of Assam, my lord. It's serial number 3, my
You
lord.
can't have remedy by both ways. You can't apply for motor vehicle compensation and then again seek this ex gratia. That will be double, what do you call, profit.
My lord, insurance company is not a government, my lord, and also an independent body, my lord, and if
Insurance is not government. How do you have that idea?
my lord,
If it's a nationalized company, nationalized
under
insurance company.
under some contract, my lord, the money is paid to the injured person.
We don't know how to, but just tell us in this police report and annexure 2.
My lord,
Met with an accident.
next, at page 15, my lord.
We asked this officer in charge of Changsari police station to be here.
My lord, Superintendent of Police has already filed a affidavit, my lord. SP has already filed affidavit, my lord.
Where is that?
In this case, my lord. Affidavit dated, my lord. 20.
No. So here this is the, so we'll call this, we'll ask this Superintendent of Police to take, to inquire into this genuineness of the certificate as annexure 2. we see a fraud here. You see, page 14 and extra 2. As this, sorry, English version is page 15. You see, here it is police report, it says he died in an accident. Correct?
Yes.
Now this superintendent of police,
Yes, my lord. In the superintendent of police, my lord, it has been mentioned, my lord, in a truck accident, my lord, it has occurred, my lord.
please don't interrupt.
Sorry, my lord.
You see, the superintendent of police, by filing an affidavit, says at paragraph 4,
Yes.
the truck has hit him. Now, how does this superintendent of police improve on this certificate issued by the officer in charge?
So yes, it's truck number has been added in this. Affidavit.
How? So the superintendent of police does not say that he has consulted the case diary. He also does not say that an accident report under 154 was sent to the tribunal as required under 150 of the motor vehicle rules. Because Mr. Barua,
Yes.
when form under 154 is issued, mandatory is there is a requirement of law to give the vehicle number when which is involved, and that is to be given free of cost to the
Victim.
person. Now the OC does not give that number. Motor accident claims can't be instituted. So therefore, this person is deemed to have issued two certificates. One to the petitioner to enable him to get a
Pursue.
necessary compensation, and second to bring it as a record in this case that there was only an accident. The fact of motor accident claims was suppressed.
But in fact, the charge sheet that has been filed in this accident case where the number has been detailed. So I think this charge sheet would be clear enough what exactly has happened.
No, I'm not on that. What is
Parallelly reading by this annexer,
no.
the certificate, yes.
You are not getting the point which I'm trying to ask you.
No, I'm trying to understand that the Supreme Police is trying to assist him in making out two different cases for one for MSCT and the other for the compensation.
For this,
So for that matter, in one, this vehicle numbers and everything is being detailed, and the
I
other,
will ask the police to inquire
yes.
as to whether the officer in charge issued two certificates, one being Annexure B at Annexure 2, and the other to be used in a motor accident claims.
From one.
Form 154.
54. Form 54.
Form 54.
54.
See rule 150 of that motor vehicle side. It's motor vehicle rules. It's required to be given. Heard Mr. W. Rahman, learned counsel for the petitioner. Also heard. Mr. Okay, but sir, when the standing counsel for the revenue department appearing for respondent number 1, finance will be there.
B Gogol,
Mr. B. Gogol and standing counsel for the finance department. And Mr. S. Barwat and the government advocate appearing for respondent number 3, 4, and 5. In this case, the son of the petitioner had expired in an accident which occurred on 26/3/2015. Full stop. There's no reference to any FIR having been lodged in respect of the said accident. Full stop. It appears from the statements made in paragraph 3 of the writ petition that the incident of an accident came to be recorded in the Chansari police station, GD entry number 127 dated 6/6/2015. Full stop. Therefore, the accidental death of the petitioner is first reported to police after about 2.5 months. Full stop. It appears from the contents of a certificate dated 13/6/2015 within bracket annexure 2 of the writ petition, bracket closed, that the police, that the officer in charge of Chansari police station has merely stated in the said certificate that one Mohammed Merajuddin, MERA, just quote this, the certificate is quoted here, annexure 2, page 14. You put a flag. Full stop. However, in the said certificate, no, it is noted from the said certificate that there is a reference to Chansari PSGD entry number 127 dated 5/6/2015. Next paragraph. In this writ petition, there is no statement that the accident occurred in a road, that the death had occurred in a road traffic accident. Full stop. However, next paragraph. However, the Superintendent of Police, Kamrup, by filing an affidavit in opposition on 17/10/2023, has introduced in paragraph 4 thereof that on 26/2015, the complainant Mirajuddin, MERAJUDDIN Ahmed, had launched an SIR to the effect on 26/3/2015 at about 2 p.m. His niece, namely Jiaul, Jiyaul Rahman, had died in a road traffic accident near Gopeswar, Gopeswar temple. When he was hit by a truck bearing number AS01CC 4534. Next para. Normally, under the provisions of the Motor Vehicles Act of 1988 and rules framed thereunder, there is a mandatory requirement of the police to provide Form 54 to the next of kin of the deceased in a road traffic accident, so as to enable the next of kin of the deceased the certificate to the jurisdictional tribunal. To the jurisdictional tribunal, so as to enable the next of kin to proceed with the motor accident case, motor accident compensation case. Full stop. There's no statement, next para, there's no statement in this writ petition that the petitioner had pursued remedy for claiming compensation under the Motor Vehicles Act of 1988. Full stop. However, from the introduction of a truck involved in an accident, it can be presumed that a certificate was issued by the police as required under section, as required in the Form 54 of the Motor Vehicles Act. Full stop. Therefore, on a reading of Annexure 2 to the writ petition, and by presuming that the police has also issued accident information to the tribunal or to the next of kin of the deceased, two certificates appear to have been issued, one without indicating the vehicle number and the other indicating the vehicle number. Full stop. This makes the certificate issued by the officer in charge of Chancery Police Station questionable, because he is enabled by the certificate issued because by the said certificate, he has enabled the petitioner to make the present claim on the basis of certificate dated 13/6/2015 issued by the officer in charge of Chancery Police Station. However, there is no information available as to whether any MSCP claim has been filed. Next para. Therefore, notwithstanding that the petitioner is making a claim in this writ petition for ex gratia under the notification of the Government of Assam dated 18/11/2014, but it is the duty of the petitioner to come with clean hands and to disclose as to whether he has made a claim for compensation under the Motor Vehicles Act. Next paragraph. Therefore, the court is inclined to direct the petitioner to file an affidavit to bring on record as to whether any next of kin of the deceased, namely Giyaul Rahman, has made any claim for motor accident compensation. Next one. The Superintendent of Police, Kamrup, is also directed to make an inquiry as to whether, apart from the certificate annexed as Annexure 2, which is issued by the officer in charge of the Chancery Police Station on 13/6/2015, any other certificate has been issued by the Chancery Police Station in respect of the same accident, and if so, copy thereof be furnished to this court. Stop. The said authority shall also inform the court as to whether the officer in charge of Chancery Police Station, MSCT, the motor accident, then motor vehicle cycle. As to whether the officer in charge of Chancery Police Station, upon coming to know about death by way of a motor vehicle accident, there were rules also, motor vehicle rules. Has complied with the provisions of section 159 and 160 of the Motor Vehicles Act of 1988 by providing information of the accident to the Jurisdictional Motor Accident Claims Tribunal. And will also inform the said authority shall also inform the court as to why in this certificate annexed as Annexure 2 to the rate petition, the compliance of Section 160 of the Motor Vehicles Act of 1988 has not been done, as the particulars of the vehicle involved in the accident has not been disclosed. Next paragraph. The said inquiry shall be completed within within 27/5/2024, and a report thereof be furnished to this court within 31/5/2024 to the learned government advocate. Next paragraph. The petitioner shall also file an affidavit by the next date of the state. Next paragraph. The Dundee government advocate shall send a downloaded copy of this order to the superintendent of police. Chancery, Kamrup, Amingaon. Kamrup rural, Amingaon. But nowadays rural is not there.
Okay.
Kamrup, Amingaon. Next, list on 31, 5/2024.
Next case also similar, my lord.
Similar.
My lord, from Sonipur district, my lord.
Here the dates will change, huh? Mr. Parikh, you understand, these are all pattern cases.
That's what,
Oh,
if one or two gets dug out of the hole, definitely they will stop immediately.
you have to facts will change, you just insert. I'm just taking the facts, I'm not looking at it. Number one. Report of the accident was made on 2/1/2021. As that was logged on 20/12/2021. No, sorry. Let's strike that. As that was logged on 2/1/2021 by complainant Rupak RUPAK Sarkar at Keshpur Police Station that on 20/12/2021 at about 6:15 PM, his son Ravindra Sarkar was going in his motorcycle, was hit by another motorcycle by AS 12 AA 3125. Here, only this much.
Well, the translation is little wrong. Like page 11 maybe Peru.
What is incorrect? I did not get it.
That the dates are to the effect that on 2020 accident.
Oh, 2020, not 21.
21.
Here, there is the only direction that the petitioner shall file an affidavit, only that much. Other directions will not be here. Huh? Only affidavit of whether any necessity claim is made, only that part will come. Other inquiry will not come. The affidavit shall be filed within 31. It is 2 days prior to the next date of this thing. Next for this one, 31/5/2021. Here we are not making an inquiry.
Here it is self-driven. Already the motorcycle.
When the name is there, we are not against it. If he has come with 3 times, there is no issue.
Yes.
29.
29.
May I please, your lordship?
Yes.
Lordship, I'm on behalf of my senior lordship. We have sought for the instruction from the PDCL authority, lordship. Instruction is awaited, lordship.
In this case, my lord,
No, you
the
have to get the government.
report from the government is required.
So Bhagwan. Here this electrician debt, you have to get the report from the inspector of chief electrical inspector.
Yes, number six.
See whether you have got it by now. I think directions were not given earlier. When you say direction, you will have to get a report.
Normally, in these cases, we file affidavit.
So since I have not come, this is a very old case, 2019 case. You get it?
I don't think it's.
Yes. You fix it after 4 weeks, please get it.
Already we have it.
You have written?
Yes. So we have.
What has come?
Yes, that's what has come. That has.
You file an affidavit. They have admitted your accident.
Accident has been.
So you have to file it from affidavit. How much time?
Can it be 4 weeks?
Oh, just one. Mr. M. Hussain, counsel to the petitioner is present. Mr. S. Bhagwan, government advocate, has submitted that he is in receipt of electrical accident inquiry report dated 3/7/2023 from the Chief Electrical Inspector -cum-advisor from the Deputy Chief Electrical Inspector. From the Deputy Chief Electrical Inspector. So forwarding letter dated 3/7/2023 from the respondent number 6. So he pays for his granted. For his time to file same by way of an affidavit. List on 27/5/2024.
I'm to the PDCL on behalf of my senior lordship.
Okay, Mr.
J. Burman on behalf of J.K. Goswami, Standing Council, PDCL.
On behalf of J.K. Goswami, standing on the APDC, is present.
31.
Okay.
May I please, Lordship?
Yes.
In this matter, affidavit is ready and by next week, we will file the affidavit. Lordship, kindly grant 1 week time, Lordship.
Okay, the de-sealing has been done. De-sealing of the premises has been done.
Actually, my senior counsel is out of station, Your Lordship. I don't know.
Okay, books as a representative on the pair made by Mrs. Ed Bhagwan and government advocate. 10 days time is granted to file affidavit in opposition in the matter. This one, give a date after 10 days.
Six, five.
Publish.
32.
Please, your lordship. Lordship, 2 weeks' time may be granted to file our affidavit, your lordship. Respondent number
Your,
6.
your reply.
Yes, your lordship.
On the next day, please be prepared to prepared for argument. Correct.
Yes, your lordship.
Specifically as the power of the court in respect of demarcation. And revenue, Mr. Bhattacharya will also be, or you are for revenue, be prepared on that day. All these matters are will be taken up, this demarcation cases and all, be prepared on the law points. Okay, also it's a representative on the prayer made by non constable repetition, list after 2 weeks, so it's unable to file. Actually, may reply in the matter.
Date may be fixed.
Date may be fixed. Give a date after 2 weeks.
15 May.
Highly opposed.
Oblige, your lordship.
33.
May I please, your lordship? Lordship, the matter pertains to the non-refund of excess TDS deducted from my account. Lordship, on last occasion, the department had sought time for filing affidavit. They haven't filed their affidavit yet.
This is which authority?
Lordship, Lordship, sales tax Assam. Taxation, Lordship.
Okay. Just make a spot for Vikram Chaudhary. Vikram Chaudhary, state GST. Wait for some time.
Lordship.
Yes, Mr. Nath, you are ready on these matters? The Lanka Municipal.
Look. Yes. B-service के दिया सर.
Who are the petitioners?
B-service base के
Mr. Kabir, we are looking for you. Mr. Kabir,
item 54 to me as
we were looking, we are searching for you.
22 to me.
This
Okay.
item number.
Yes, Mala, he's there, Mala.
No.
Item
This is
54.
Kabir.
Lots of we have received instruction. I pray for 2 weeks.
2 weeks time. Okay, both sides are represented. Mr. V. Chaudhary, standing counsel for the state GST. Somebody said he has received the instruction that there is for 2 weeks time to file affidavit in opposition in the matter. There is about. Okay, this one, give up 2 weeks. Same thing you can make 15.
15. 15.
Plus business.
15 time.
I think item 54. Yes.
Yes.
54, item 54 to listen.
Lordship, petitioners were the fitta holders, Lordship. Petitioners were the fitta holders and patta holders in the business shop center under Lanka Municipality.
They are not patta holders.
Patta holders, Lordship. They have got patta, Lordship. Annexer 1 series, Lordship.
Patta?
Patta holders, Lordship.
No, this is only for a shop. Patta would mean a lease year.
Lordship, that I got not.
Patta would mean a lease year.
Lordship, kindly go to Lordship, Annexer 1, Lordship.
Under the Assam Land and Regulation, patta is only a lease.
But they have used the word patta.
We understand, patta itself is a lease.
Lordship.
Patta is a lease of 15 years or 30 years.
30 years. A periodic.
Periodic patta.
Periodic.
Patta is a lease.
Annexer 1 is the patta certificate, Lordship.
Do you know patta? This is for the third time you are asking, repeating that name patta. Do you know the meaning of patta? Have you read Land and Revenue Regulation? Have you read Land and Revenue Regulation? What is a patta? Please tell us. You see, we don't become a lawyer without reading Land Revenue Regulation in our college. Now, please tell us, have you read what is a patta?
Okay, patta is the settlement given to somebody for 30 years and
But it's a lease of 30 years.
Lordship.
So that is called a patta.
Lordship.
Then, so what, when I said that it's a lease, you controverted saying no, it's a patta. What is a patta?
Lordship, according to the municipal committee, they have used the word.
It's okay, we have heard you.
But under the under Lanka Municipal Board, Malad, at present they have 3 projects. Number 1 is Lanka Multi-Story Business Center, and number 2 is Purely Fukon Market at Lanka.
Just a moment.
Lordship.
Please repeat the names of the markets.
Malad, Lanka Multi-Story Business Center. Business center, in the business center, Malad, in the ground floor, there are 47 shops.
Yes.
Malad, we have subsequently the board has constructed first floor and second floor. There, Malad, 51 and 51 shops are there in first floor and second floor.
Yes.
As per
how many were the original shop owners is there?
no, in fact, Malad, in 2014-15 that process was started, but thereafter the construction, first floor, second floor construction.
No, that is one part.
Logic.
I am on the earlier part. Where before the construction started, how many people were given allotment of shops there?
But this type of this settlement at NHR 1 series he has annexed in this petition, but this has come for the first time. Kindly, that is one aspect. Not this type of
No, we'll tell you because this is a matter we are handling it on many occasions. That's why on the last time we wanted you to consolidate.
Well, that 300 things will come in the next in the other project.
Not in this.
Not in this.
Okay.
Well, here that is why I'm indicated that 47, 51, 51.
Okay.
51, 51 construction is not complete, and in fact 47 only will first in the ground floor only will some.
Yes.
Here, Malad, under for this project, Malad, claiming their settlement or Malad, allowing them to do business. There are 5 cases, including this 6. This will be 6.
Yes.
The present case will be 6, Malad. 5 cases are there. Their notice has been issued, and ultimately the thing is that Honorable Court has directed the Deputy Commissioner to examine the process, what they have done. And because the DC is in session of the matter, the board has not allowed anybody to start business there. As
Okay.
this is as
You
this,
have the date of order of the court.
Malad, WPC number 308 of 2023, but 5 cases are there, Malad.
WPC. No, this order of the court to direct the deputy
Commissioner. Yes, yes,
inquire.
yes, Malad, I have. And in fact, Honorable Court orders are there that not to allow or keep to
Just give me the date, we'll get it from
yes,
there.
yes, Malad. Logic. I have 5 numbers, 5 cases, not just I'm indicating the other project.
Okay, WPC numbers.
5 cases, at present pending. 308 of 2023.
Yes.
8258 of 2022.
Yes.
Their interim order is there, 1235 2023.
Get this order. 8258.
8258 of
There is an interim
2022.
order.
There is an interim order.
Okay. Then
1235 of 2023.
yes.
Interim order is also there,
Okay.
to 9 shops to be kept vacant. That is the order,
1235.
1235 23.
23, okay.
The other writ petition is 3501 of 2022.
Okay.
Logic.
These 2 cases get the order.
And one more number is there,
Okay.
7137 2019.
Yes.
There, I'll take your lordship to those, but the claims are, somebody claims that I am earlier lessee, give me. Somebody says that you have settled me. I have deposited the money, give me. New persons who responded to the settlement process, they have also filed some cases. The others have also filed some cases. Ultimately, the Deputy Commissioner has been directed to look into. So far, the purely Fukun market Lanka is concerned, there we have cases, some cases are pending. This present petition item number 54 is concerned with that market. Oh, sorry. This is Lanka Business Center only. Business Center only, sorry.
Yes.
This is relating to Business Center.
Yes.
Kindly
Business
see,
Center.
kindly see their petition. They page 6 it starts. Their only grievance is that we have filed a representation before the Deputy Commissioner, and it has not been considered. Kindly come to
yes, correct. We've seen that 22-2024.
yes.
Yes.
That is their case that you consider our representation. The purely Fukun market Lanka, which has the largest number of rooms, in purely Fukun market Lanka, 344 rooms are in the ground floor.
Just a moment.
Logic.
In this case, he's already concerned with this business center.
This particular case, item 54, is concerned with business center.
So here, what you have, what is the nature of instructions you are having?
No, here this has come for the first time.
Okay.
On Wednesday, it came.
So we issue a notice here that the authorities
Logic.
consider.
Yes. I will get the instruction from the Deputy Commissioner what ultimately he has done.
Okay.
On the logic.
Okay, let me pass an order here.
Malad.
For Mr.
Ahmed Saikal,
Ahmed Saikal, I'm a counsel for the petitioners, and Mr. D. Nath, Leonard, Senior Government Advocate.
It is.
Appearing for. You will be for all the respondents?
Lordship, record my name for all the respondents.
For all.
All the respondents. So, next paragraph. The petitioners claimed that they were the earlier VITA holders in Lanka Municipal Market, where a new business center is being constructed. Full stop. The petitioners have submitted their representation dated 20/2/2024, which has not been disposed of, and therefore this writ petition. Next, issue notice returnable in 4 weeks. Requisite extra copies of the writ petition is served on the learned senior government advocate within 2 days. Next, the pendency of this writ petition shall not be a bar for the respondent number 3, Lanka Municipal Board, dispose of this said representation with due intimation to the learned senior government advocate.
My interim order maybe.
What is the interim order?
Interim lordship, not stop remodeling of the shop rooms allotted to the petitioner lordship.
No, it is not a decision of the
No,
authority. But in the ground floor, 47 shops. But they claim that in the first floor and second floor also, there should be 47 shops only. It is as per their plan and program. They have they have made 51 shops in the first floor, 51 shops in the second floor. So that they cannot dictate us.
No, we are not in state.
Lot.
We just add there. Notice including notice to read. Space we are not granting. You consider later on. The shops, next the shops, if any allotted, will be subject to for the orders that may be passed in the writ petition.
They have given the representation to the deputy commissioner. But the allotment is done by the municipal board.
No, we have said municipal board. This representation is to deputy commissioner.
Is to the deputy commissioner.
Oh, no.
Not to the board.
Where is that?
At page 77.
77.
Is it translated copy? 79 is the vernacular.
But I issued a direction on respondent number 3. No, then we dismiss your writ petition.
Lordship, because now the deputy commissioner is handling the matter, lordship.
But he will not be able to do anything. Municipal board shops, deputy commissioner will not allot. He has no power to do it. How municipal shops will be given by the district commissioner? No.
Lordship,
Then we are dismissing our writ petition.
Lordship, the Honorable High Court ordered the deputy commissioner to inquire
So
the matter.
anybody who want to inquire will be the authority to decide it. Supposing for some incident, we today ask the police commissioner of Tinsukia district to make inquiry in Guwahati. Let us say we do it. So everything which happens in Guwahati will be under control of the Superintendent of Police Tinsukia. No, we dismiss your resolution. We give you liberty to move the competent authority. Inquiry will be made by anybody. Last part is it is noticed from the copy of representation dated 20/2/2024. Which is annexed to this writ petition is Annex 3. That the representation for inquiry in respect of allotment of rooms is made to the district commissioner of Bhadai. It is submitted that orders have been passed in various petitions to direct the district commissioner of Bhadai to make an inquiry. Next paragraph. Maybe because this court had directed the district commissioner of Hosai to make an inquiry, would not make him allotting authority in respect of shops which are existing and are being constructed in the Lanka multi-story business center. As the municipal is the Lanka Municipal Board is the authority under which this market is to operate. Full stop. Next, therefore, the court is inclined to close this petition with liberty to the petitioners to make representation before the Lanka Municipal Board. So with the forced liberty to replacement stands closed. Yes, continue. Other matters.
Lot
20.
Kindly take up item 20.
Item
20.
Yes.
There, Lordship has passed an order.
Just a moment. Mr. Nath, in these orders, there is no direction on the deputy commissioner to make an inquiry. At least in these 4-5 cases you have heard.
But that is in respect of possibly that is some
whatever be, but we are not.
Some cases have been disposed of. Maybe in that with that direction
Okay,
disposed
but
of.
in these cases you have referred. We have got copies of all the cases. Is not there.
These cases are pending. I'll give.
Okay, in item 20.
Item 20, item 20, all the other items, 20, 21 and the other item, those are relating to purely Fukon market Lanka. Their Lordship has passed an order on 5-4.
Yes.
On 5-4.
Purely Fukon market.
Purely Fukon market.
Yes.
Their Lordship may kindly note, my lord, 344 shops in the ground floor. And 344, these are running.
Yes.
152 in the first floor, 152 in the second floor.
Yes. These are completely completed and running.
No, all are not. Only first floor is ground floor is running. 344 is running.
Okay. So then there will be no difficulty in accommodating because there are only, earlier there were only 318 Vita holders.
Lordship, they have been already considered. And now so many cases are pending, my lord. Including these three, other cases are also pending. 1470 of 2023 as regard purely focused on market plus.
No, but this is something which is not appearing anywhere. That all the earlier allottees or Vita holders have been accommodated. There's nothing on record to show that.
Well, they have, for allotting the shops, they have initiated a process. And apart from that, they have also accommodated them. And thereafter 150 to 152, another 344 in the first floor and second floor process has been initiated. That resolution, Lordship may give me some time and that resolution I'll place it.
You bring it on record.
Yes, I'll bring it.
Okay, because
I'll bring that.
I might have missed it, but I don't get it.
I'll
don't
place it. I'll place it. I'll place it. Yes. But on 5.4, notifies directed me to obtain the numbers. These three,
Yes,
along with these three, kindly, my lord, 1470/2023.
Okay, because you see, in this case, you have filed a affidavit.
Yes.
There also, there's no clarity about all the
No, my lord.
Vita holders being
no.
allotted.
No, my lord, it is not there. It is not there. 9.
Both sides are represented. Pursuant to order dated 5/4/2024 from Mr. D. Natlan, senior government advocate, appearing for all the respondents, has submitted that as per instructions received by him, in the purely Fukun market, which is operated by the Lanka Municipal Board, there are 344 shops running in the ground floor. And $152 shops have been constructed in the first floor, and 152 shops have been constructed in the second floor. First off, it is submitted that after allotting land to the earlier Vita holders,
shops.
No, this shops is to the earlier Vita holders.
Earlier, allotting these shops.
Vita holders.
Lordship, this is my telephonic instruction. Kindly let me place the resolution below. Earlier Vita holders have been already taken care of. That is my instruction.
Okay. Earlier Vita
I'll
holders have
place
been taken care of.
Okay.
So however, he submits that this was on the basis of a telephonic instructions, and it waits for some time to get written instructions and to address the court.
No.
Next paragraph. The order of status quo, which is passed and connected, WPC 1064 of 2021, is extended till next date of this week. Next, this matter. When?
Kindly give me 2 weeks time.
We date after 2 weeks.
Logic.
We make it in 15/5.
15/5.
This one 15/5/2023, 24, along with WPC 3213 of 2020, 1064 of 2021, And what are the other cases?
147023, 14702023, 28952020. Gotcha.
Okay.
These are relating to purely Fukan. And there is another project, Mulab.
That's not before us.
That's not before. No, there is a case, but it is not listed there. Case is there,
No, that's okay.
not listed. Gotcha.
This we'll call that also. I don't think that will complicate the matters. Once we are taking up this purely Fukan, let us take purely Fukan together.
Main problem is with this Lanka Business Center and purely Fukan.
We take individual markets together.
Logic.
Together.
Lot.
Timing item 23.
Out of large logic.
Yes, PNRD. PNRD is not there. You've given us call for PNRD. SC PNRD. Panchayat and Rural Development.
I could not find out any ordinance.
So let me give us call because adjournment is not desirable. Wait for some time. Just try to find out if they are there.
Item 35.
Yes, here also this
These are my lord that
motor vehicles is not
Lordship.
mentioned. Yes, in this case, he has mentioned it. So we allow this registration and this compensation.
Lordship.
Shall be adjustable with the motor accident claim.
Yes, yes. Motor accident.
Yes, revenue.
Lordship, I have done, you have a revenue report.
Yes, what is your stand in this? What is your stand in this ex gratia?
Yes, your lordships, my lord, that we have to, my lord, the receipt from the deputy commissioner regarding my lord whether he is entitled on.
No, you come to page 23. That is the notification.
Lordship, yeah, that is
Now,
true.
the query of the court is that whether this ex gratia is exhaustible against the award by the MSCT tribunal.
Oh, that is not mentioned in this, my lord, that in the
So,
non-notification.
so what is your stand? What is the department's stand?
This departmental stand is that, my lord, as per the death notification, when the, my lord, the person who has been, my lord, that death or my lord, that injured, my lord, that as per the, my lord, that notification, we have been paid to the 2 lakhs rupees for a dead person. Whether it is adjustable, my lord, or my lord, that it is in the, my lord, others, my lord, the MSCT petition or MSCT appeal lawsuits, my lord, that is not mentioned in the, my lord, notification.
No, but what is your stand? That's what we are asking.
So the letter without my lord, that instructions, I cannot say, my lord, oh, my lord. So we already been, my lord, that stated that, my lord, they have been, my lord, entitled to 2 lakhs rupees when the person who was accidentally dead. Lordship, can we given some time to obtain instruction?
Just a moment. There is a case of Shashi Sharma, decided by 3-judge bench of Supreme Court. It's National Insurance Company versus Reliance General Insurance
Reliance
versus
Lot-
Shashi Sharma. This judgment it has been interpreted that pecuniary advantage from whatever source must correlate to the injury or death caused on account of motor accident. Therefore, if ex gratia relates to accidental death arising out of motor accident, and motor accident claims tribunal compensation also arises out of the same, then it must correlate. You be prepared, you give it the citation, be prepared on the next date.
In the paragraph
This-
26 also, my lord, specifically stated.
2016 9 SCC 627. You address us on that point. When do you want, Mr. Rahman?
My lord, after 4 weeks, my lord.
Uh, both says are represented. It appears that in the case of Reliance General Insurance Company Limited versus Shashi SHI Sharma and others, within bracket 2016, bracket was 9 SCC 627, comma, amongst others, comma, it has been held to the effect that pecuniary advantage from whatever source must correlate to the injury or death caused on account of a motor accident. Full stop. Therefore, ex gratia arising out of, therefore, next paragraph, therefore, comma, the query of the court is whether ex gratia receivable on account of motor accident death and claim made before the motor accident claims tribunal, which also correlates to the on account of motor accident, can be interpreted and understood to mean that the quantum of compensation receivable under the ex gratia scheme of the government of Assam would be deductible from compensation payable as per award of the motor accident claims tribunal. Next, on the query, on the said query report from the Mr. W. Rahman and counsel with the petitioner, as well as Mr. J. Andy Planet, standing counsel for the revenue department. Please some time to address the court. List after 4 weeks as paid for.
Obligation.
Item 36.
Because I have to rise.
58 and 59.
Was pleased to pass an order on 22nd of April 2024, Malaj, by which the petitions of under section 11(6) was allowed by the Honorable Court. Malaj, the Honorable Court has proposed the name of the retired Malaj justice from this Honorable Court. Malaj, the only difficulty, Malaj, in terms of Malaj, what we have been able to find out, Malaj, is Malaj, there's a Gujarat High Court judgment, Malaj, which goes actually in the favor of that, yes, the retired judge who has conducted the proceeding also in the matter could be appointed as an arbitrator. Malaj, but that matter, when it went as a challenge before the Honorable Supreme Court, Malaj, I just show the order, Malaj, for a moment. Yes. Malaj, could see for the moment, Malaj, the Supreme Court judgment, Malaj, which was, it's only a small judgment, Malaj, order, Malaj, on first paragraph, the Gujarat High Court, by its impugned order dated 10th of November 2023, dismissed the petition under section 12(5) of the arbitration conciliation. The petitioner had objected to the arbitrator nominated by the respondent on the ground that he had previously acted as a judge at the interim stage in a matter arising between the same parties pertaining to the same arbitration. During the course of these proceedings, the arbitrator in respect of whom an objection was raised has withdrawn from the arbitral proceedings. In this view of the matter, the cause for which the cause which was sought to be espoused in these proceedings will not survive. Now, this is important. Fifth paragraph. The impugned order of the Gujarat High Court dated so and so shall accordingly stand set aside. So, the order by which the Gujarat High Court said that this is correct, even though the arbitrator has withdrawn himself, the Honorable Supreme Court, so as not to make it as a precedent, has set aside the order. My only anxiety today is, tomorrow, there's another judgment, I forwarded of Honorable Delhi High Court, that judgment indicates that if a proceeding is being conducted by an arbitrator who was de jure otherwise not competent and ineligible to was ineligible to conduct the proceedings, the award passed by the arbitrator. Yes, Malaj. Yes. Para 3, Malaj, would be important. 5. Just for the background, Malaj, and the relevant portions would be, Malaj, para 14. At the bottom, Malaj, page 4 of 6. Para 14, Malaj, there's a reiteration of the.
Just now, no?
Yes, Malaj.
I'll tell you what has happened.
Yes, Malaj.
Why the Supreme Court has intervened.
Yes, Malaj.
Read paragraph 16.
Yes, Malaj. I've already noted down, Malaj. It's an interim order which was
So you see, once there's an interim application under section 9,
yes, Malaj.
then you go into the merit.
No, Malaj. What has
Or the
happened is,
claim
no,
or-
Malaj, this is the case, Malaj, where the arbitrator conducted a hearing of section 17, Malaj. That section in 17, Malaj, was being decided in one of the parties' favor, Malaj. That went in a challenge under section as an order before the Honorable and 37 before the division bench, Malaj. The Honorable Division Bench checked the veracity of the order and said that the order is correct, Malaj. Malaj, later thereafter, Malaj, the presiding arbitrator died, Malaj, unfortunately, and another arbitrator who was, Malaj, the nominee arbitrator, also recused himself from the proceedings, Malaj. But then the parties whose nominee arbitrator was recused had sought for an appointment of an arbitrator who was one of the members of the division bench, Malaj. So, Malaj, they have practically not gone into the merits of the case, Malaj. Whereas in my case, Malaj.
No, it's not a question of merit.
Yes, Malaj.
You see, once you decide an appeal.
Yes, Malaj.
Then you can't say that you have not gone into an appeal. Even if I dismiss an appeal at Nimini.
Absolutely, Malaj. You have touched on the merit somewhere, Malaj. Malaj, but my case also, Malaj, they have been touched on the merit, Malaj. Malaj would see there's an opinion and there's Malaj would see the order for a moment, Malaj. The order which is there, Malaj. Malaj, I am only saying, Malaj, today the situation is, Malaj, there I've also produced of the Delhi High Court, Malaj. I'll just show the order. But Malaj, I've also shown the Delhi High Court, Malaj, which very categorically says, Malaj, and Malaj would just see the relevant portion, Malaj, would be at page number 6 of 13 and paragraph 13, Malaj. Malaj, looking into all the judgments, the Honorable Court, Malaj, would see at page number 12, page number 9 at para 22. has Malas gone into the details, and Malas has at para 30 has said, in view of the above, it has to be held that the learned arbitrator was de jure ineligible to act as such, and the award passed by the learned arbitrator is void and unenforceable. Therefore, the same is set aside. So, Malas, my anxiety today is, Malas, tomorrow, if anywhere in the entire country, Malas, there is some proposition of the similar nature pops up tomorrow, Malas, and the Honorable any High Court or Malas Honorable Supreme Court for that purpose makes out an observation that no, this is covered under de jure, as Malas has been rejected by the Honorable Supreme Court of Gujarat High Court, Malas. Now, what will be my fate in tomorrow, Malas? I have conducted the entire arbitral proceedings before a person who will be declared by any of the competent courts to be de jure, Malas, ineligible. Malas, the award, even if passed in my favor, would also suffer in illegality, Malas. It will not be enforceable. Much obliged. Malas, just for a moment, Malas, I want to show one category observing. Malas would see that order, Malas, would see annexure 4, Malas. Annexure 4, page 42, Malas. 41, it starts. This is an order of 10th of 11/2023 of the proposed arbitrator, Malas. Malas would see, heard Mr. S.P. Sharma, learned counsel for the petitioner, also heard so-and-so learned counsel for the respondent, and so-and-so learned counsel for the respondent number 2. In the contract matter between the parties, the dispute has a reason which requires to be adjudicated. The terms of the agreement provides that the dispute shall be referred to the dispute board for its adjudication at clause so-and-so, and clause 2.2 also further provides that if the parties have not jointly appointed the dispute board within 21 days before the date stated in the contract data, where the dispute is to comprise of 3 persons, each party shall nominate 1 member of the approval of the other, and the first 2 members shall recommend, and the party shall agree upon the 3rd member, who shall act as a chairman. Clause so-and-so of the agreement provides that, amongst others, if the parties fail to agree upon the appointment of the sole member of the dispute board by the date stated in the first paragraph of clause 20.2, which is understood to be 21 days, the consequence thereof would be that the appointing entity or official named in the contract data, which is in the instant case is the state to be the Institution of Engineers India Assam State Center, shall appoint the member of the dispute board. By referring to the provisions of 21 days in the clause 20.2, Mr. S.P. Sharma, learned counsel for the petitioner, makes a submission that as the appointment of the dispute board could not be done within the period of 21 days, therefore the contract data does not provide for appointment of a dispute board any further, and the alternative means of an arbitration would have to be resorted to. Now, this is the observation, Malas. A plain reading of the clause 20.2 and 20.3 do not make it discernible that if a dispute board is not appointed within 21 days, there would be no further appointment of a dispute board, whereas the provisions appear to be explicit that in the event of failure to appoint the dispute board, it will be the appointing entity or the official named in the contract data who shall appoint the member of the dispute board. At this juncture, Mr. So-and-so, learned counsel for the petitioner, prays for the adjournment to be examined the matter. Now, there's an application, a judicious application of the mind, Malas, where the Honorable Court was of the opinion that the petition itself is not meritorious, and Malas, it is not maintainable. Malas, Malas, could it be on 3rd of May, Malas, possible? On next Friday? Yes, Malas. Malas, only my request is, Malas, there might be an abeyance of that 3 days order, Malas. Deeply obliged.
My lord, for respondent number 1, they are appearing.
I'm appearing for respondent.
He would turn, Malas. Deeply obliged, Malas. Much obliged.
W. Ahmed on behalf of B. Chaudhary. B. Chaudhary. I'm appearing for respondent number 1.
Malas, we have also given the copy to respondent number 2, Malas. It says it didn't appear, Malas. Deeply obliged. Much obliged. Plus, there's a 18 also on petition. But there are two petitions on this, 18 also. Deeply obliged. Manoj, could it be on the higher side, on the number, Malas, could it be on the earlier board, Malas, in the first 10 matters? Like, could it be Malas, the matter could come in the first 10 matters, Malas, earlier on the board, Malas, earlier on the board only for the purpose, Malas, so that it can be heard and Malas decided that petitions otherwise have been decided, Malas. I appreciate. Deeply obliged, Malas. I appreciate. Yes, Malas. Deeply obliged, Malas. Deeply obliged.
My lord, we have taken. My lord, with regard to respondent number 2, we have taken steps, my lord. The notice has been given. The receipt copy.
So,
My lord, item 57, can it be fixed lordship on 6th? 6th of May? Obliged lordship.
Lordship, in item 42, there's an interim. Kindly be extended, please, Lordship. Obliged, Lordship.
Regarding item number 55G, orders matter, earlier order may be, interim order may be continued till the next date, my lord. No. Item number 5050. My lord, here is a problem, all respondents are, service are completed. Only regarding respondent number 8, insufficient address not completed. Maybe order, my lord, correct addresses for 8 regarding respondent number 8. For insufficient address, service is not completed, but all respondents are completed. So, my lord, I claim your lordship regarding a correct address may be my lord. Earlier interim order. Mass.
Computer 82%. 52%.
Hi, sir.
All right.
How are you, sir? Sir? Thanks, sir. Thanks, sir.